Ghana is 64 years today, and chairman of its major accountability institutions board still has a job, even at 82 years. He got a 76-year-old president who won elections on a campaign against corruption to force a 60-year-old proven anti-corruption champion to retire. Couldn't be allowed to expire his term in 4 months, 2 months really. But why are governance and anti-corruption CSOs angry, calling the action unconstitutional and shameful? The morning after the December 7 election, many Ghanaians and governance experts celebrated what they asserted was a clear desire voters had done away with a rubber stamp parliament for one that would hold the imperial presidency and executive in check. But why are opposition MPs under siege, unprecedented, for betraying the trust in approving minister nominees who appear to have been roundly rejected by the public? The Supreme Court declares Mohammed's petition is not frivolous, has reasonable cause, yet dismissed it for being without merit. But why? Does he not understand this and takes the courts on while accepting the judgment? I'm Samson Ladi Anyanini. We have the next 3.5 hours to canvass these vexed matters for you on Independence Day. We'll be right back. You're welcome back. This is NewsFile, it's your most authoritative news analysis platform. And here on NewsFile, as you know, we put Ghana first. And here is your legal light, Anyanini legal light. Criticize rambunctiously, measuredly. I have followed the discussion and the debate about whether or not the courts, the Supreme Court, can be criticized. I think there is no debate about that. There are public officers. They sit there to administer justice for and on behalf of their people and not for themselves. One of the ways to hold them accountable is to criticize them. So I was delighted to hear Justice Yoni Kolendi convey the message of the Chief Justice that the media, and for that matter, the public, is entitled to criticize the judgment that has been delivered violently, underlined, violently. Now, I just share just a portion of some statements in a judgment that was delivered in this country in 1994, when the newspaper and journalists got into trouble for calling a judge of the Supreme Court, who soon after became a Chief Justice, calling him a liar. Why? Because they reported that they had heard him render his judgment in the famous 31st December case and had attributed a statement to Dr. Busia. And that statement, in fact, was not Dr. Busia's statement, but it was the Daily Graphic's editorial opinion. But subsequently, when he published it, the judgment was made ready, was giving out, and it was found that it was not there the way he had put it. that he had previously obtained a copy. And in that copy he said he had previously obtained, what he heard was captured there. So he went further to accuse the judge of actually tampering his own judgment by seeking to remove what had been there out. That was the case of Republic versus Mensah Bonsu, ex parte Attorney General. It is the case that has been famously referred to as the page 28, the famous page 28 judgment. In that judgment, the Supreme Court said, this is what you can do to the court or to them. Criticism of the courts and of judicial decisions, however rambunctious, whether or not in good taste, and despite inaccurate statements of fact, would not amount to contempt of court and is within the limits of the inalienable rights of every individual's freedom of speech. You need to play this back. However, it should not be forgotten that there are limits to the freedom, and therefore, even though one is in fact criticizing, if imputation of improper motives are attributed to those taking part in administration of justice, calculated to interfere with the administration of justice, a publisher of such matter would not be immune from contempt. Now, she belonged to the group that ruled that contempt had been committed. One of the judges who dissented and disagreed, however, gave this caution. He said, the language of criticism must be temperate and measured. Tempered and measured. So criticize as violently as you can, but ensure that you are not scandalizing. That is criminal contempt. It is part of the contempt I wish will be removed from our books. Be measured and tempered. That's your legal light. My guest for this morning, Kweku Asare. He's fellow CDD Ghana and D&D fellow for public law and justice. He's joining us from the United States of America. Thank you so very much, Professor Kweku Asare, for making the time this morning to join us.
Thank you for having me, Samson. I appreciate the invitation, especially on Independence Day.
Right. We appreciate your sacrifice. We know what time it is where you are. Yao Diopong is lawyer, senior lecturer, Ghana School of Law, and member Akufo-Addo's legal team in the just ended petition. Dr. Reina Akumperia is lawyer and member John Mahama and NDC's national legal team. Gentlemen, thank you very much for making the time to join us.
It's good to be here.
It's a pleasure to be here.
Shortly, we will also be joined by Dr. Ernest Kofi Abochi, who is Dean, UPSA Law School. Now, without much ado, we will go straight to our very first issue that we are canvassing for you. And as you know today, special Independence Day, we are here until 12:30. And this show is brought to you by the candid sponsorship of Bank of Africa, as strong as a group and as close as a partner. MTN Everywhere You Go, Ashasi University, educating ethical and entrepreneurial leaders for Africa. Duraplus, where Duraplus goes, water flows. Having mosquito spray and coil, pleasant on humans, tough nightmare on insects. And Napa Foods, it is tasty. DBS Industries, if you're looking for anything roofing that is lasting, that is where to look. Robert & Sons Limited Optical Services, your comprehensive eye care services provider. So let me begin with Professor Kweku Asare. Now, you were one of those who suggested, when the Auditor General, Daniel Yaw-Domelevo, was asked to go on leave for 167 days, you were one of those who suggested very early on that that amounted to sort of some constructive dismissal, and you did not just stay with criticism in the public. You actually proceeded to the Supreme Court to challenge the basis and constitutionality of what happened. What do you make of the latest?
Well, Samson, thanks again. I'm not too surprised by the latest. And for us to make progress, let us go back to the pre-independence days when a profound statement was made by Dr. Nkrumah to the effect that seek ye first the political kingdom, and all else shall be added unto thee. And over the years, that statement has been interpreted in diverse ways. One school of thought believes that that statement means if you are able to obtain executive power, that's the political kingdom, that's the executive power, all else, all the institutions of the state could easily be added. Unfortunately, including the institutional buffers of our democracy, the independent constitutional agencies, the Ministry of Justice, the police. If you are able to garner the political kingdom, then you can co-opt all that. I call that the winner takes all governance approach, or WIGO for sure, WIGO. So there are some in the country who believe in this WIGO ideology, politicians, as well as even independent constitutional officers. Then, of course, there is the Fourth Republic Constitution. When you read the preamble, it talks about limited government. Government only has power to the extent that that power has been allocated to it by the Constitution. And I've called that good governance, go. So there's a constant struggle since our independence between those who stand for go and those who stand for WIGO. And I believe some of that is playing out here. I want to ask the question, well, why would the president even do this? What is the theory to explain what has happened? In my opinion, the president did an economic calculus, and he reasoned that the benefit to him from dismissing the Auditor General outweighs any cost to him. Costs include losing some votes and voters, losing some believers in constitutional governance, losing even some people in his own party who are sticklers for good governance, perhaps being smacked down by the Supreme Court, but he has to calculate the probability that the Supreme Court will smack him down. And I believe that calculation was that maybe it won't happen. And then you have to weigh it against the benefit to him. What is the benefit to him of dismissing the Auditor General? The benefit to him is that this Auditor General it's not the Auditor General auditing the presidency and the other executive agencies. Or this Auditor General is so, I don't know the word, it's so maybe effective that we don't want to expose some government dealings and government documents to him. So it's a cost-benefit analysis. And in the end, the president calculated, look, I have to dismiss the person. Now, having decided to dismiss the person, then the question is, what tool do you use? What tool do you use? The tool that the president used was the Audit Standard Board, the Audit Service Board, the board, right? You know, the board has 3 nominees from the presidency, including Professor Ajimariya, who incidentally is a former Auditor General, and we should never do that again. Allow a former Auditor General to sit on the board of the Audit Service. Once you serve, you should be allowed to go. You shouldn't be allowed to come back and interfere with the function of the extant Auditor General like is happening now. So the auditor, the board was the tool. And he would go through the board, and you see that the board will go and dig and dig and dig and find something. It's one thing or the other. First, it was, oh, you haven't taken your leave, and so go on 167 days leave. And then as the 167 days approached, they tried to find something. They went to do an audit of the Auditor General. They hired a private accounting firm to do an audit of the Auditor General, which, by the way, is also unconstitutional because that is the remit for Parliament. That auditor found nothing. So then they had to do something. I believe they hired some independent investigators, and they unlawfully assessed SNIT data. I believe Surcharge should investigate how they got the Surcharge data, and furthermore, how someone's social security records were leaked so shamelessly onto Facebook. If you are going to be a country and you are going to trust our institutions, if I give my information to the social security people, SNIT, I expect that that will be kept confidential. The presidency doesn't have any power to have access to that data, let alone leak that data shamelessly to Facebook. And if that happens, there should be consequences. This cannot happen in just about any country.
It's a breach. It's a breach of the Data Protection Act.
It's a breach of the Constitution because this is a privacy right. It's a privacy right. And so they went to that route. The auditing route failed. Then the investigators found something. They said the citizenship, he was Togolese. Very dangerous. Very dangerous. Here you are, you wrote a memo saying the person's mother is a Ghanaian, and you are saying the person is a Togolese. How low can we get in the country? And then they went to the age. The age, they said the passport says he's 59. The baptismal record says he's 59. All the documents say he's 59. But we found some corrected data which said he's 60. He was born 1 June 1960. So that is the one we are going to stick with. It's almost like the elections that we did, and then somebody says the Electoral Commission changed numbers, and we just want to stick with one number that he said is wrong, but we want to stick with that. Here we were with the president challenging that type of thinking, and yet using the same type of thinking when it comes to the Domlevo case, where on the record, it is clear that he's 59 and has, as you said, only 3 months to serve. And yet, because of the economic calculus, he felt Domlevo has to go. And in all this,
and on on the Senate beneficiary form you talk about, the beneficiary form that he signed on the 25th of October, 1993, the SNIT number actually reveals he was born on the day he insists he was born and the date he insists he was born, correct?
Yes, correct. And you see, that document that was leaked, and I strongly suggest that Surcharge should investigate. I believe that document itself is doctored. Because if you read that document carefully, you find out that there's the date of birth which says June 1, 1960. But when you look at the SNIT number itself, and you know how to read the SNIT number, you find that that says he was born on June 1, 1959.
Yeah. Many people cannot interpret SNIT numbers, so they wouldn't know.
Card with those two numbers, those two data points, because they are inconsistent. And the reason they are inconsistent is because somebody is messing with the data. And that's a shame.
But what do you know how about the same form? What do you make of it? So what the president has informed us now is that he has taken a decision on the basis of a beneficiary form. Now, what do we know? Does a SNIT beneficiary form effect a change of dates of birth and nationality?
No, absolutely not. Of course, these are even judicial questions. The president doesn't have the power to make these determinations. If you doubt that somebody is not a citizen of Ghana or somebody's age is not his age, you don't decide that at the office of the president. You go to court, like they did with the Balongun case and the Shalabi case and the Olympio case and so on. And in each of those cases that I cite, the government was actually found out to be wrong, because citizenship is very complex. And in the case of Demlevo, there's clear evidence that he's a Ghanaian. It's even preposterous to waste any time, talking about the fact that he's not a Ghanaian. And the age issue is equally preposterous, because we have his baptismal record. We have family members who can tell us when he was born. We have his passport. We have so many documents, and then we are insisting on this one merely because this one allows us to perpetrate an agenda. There was a predetermined agenda to get rid of the guy. And look, if it wasn't the audit or the accumulated leave or the citizenship or the age, it could have been something else. When he was in secondary school, he did not go to the farm when he was supposed to go, and therefore we are getting rid of it. It's laughable. It's laughable. Okay. Now, Samson, the presidency, of course, is clearly at fault, but we will miss the picture if we don't put the blame, the ultimate blame, in the proper place. The Constitution itself anticipates these type of disputes between independent constitutional officers and the people that they exercise and the other branches of government. So, for instance, the Auditor General audits the presidency, and one would expect that there will be friction if the Auditor General keeps finding expenses that the president is incurring that he's not happy with. The natural tendency of any president is to get rid of it. And government itself is of limited power. There's separation of power vertically and horizontally. There are checks and balances. For all that to work, you need someone that is charged with enforcing the Constitution. And the beauty of our Constitution is what I call the triangle defense to enforcing the Constitution. The Constitution gives standing to anyone who feels the Constitution is being violated to go to court. And when you go to court, they have jurisdiction. They can't say we won't take it because the Constitution compels them to take the matter. And so in this case, we went to court. I went to court in July last year, and the court basically dismissed an injunction and then took a vacation on the substantive issue. They came back. Up till now, the court has not found that the case is important enough to adjudicate it. The CSOs filed another rate in October. The same thing has happened to that rate. So you see that there is a clear abdication of responsibility by the court. And I loved when you were talking about your, whatever you call it, your legal talk, rambunctious and all that. Well, look, it is not what people say that really affects the administration of justice and whether or not people respect the justice system. It is what the justices themselves do that influence how people view the court. So if you compare this Auditor General case to the December 31 case that you cited, the then government announced that it was going to celebrate the December 31 revolution on December 12, 1993. Immediately, the NPP government, not the NPP government, the NPP as a political party sued the Attorney General, and the court ruled on the matter before December 31. It took the court a mere 10 days to instruct the parties to file all their papers and their writs and their arguments. And the court determined that because the court realized that if it did not decide the matter before December 31 and allowed the December 31 events to be celebrated, then it has taken sides by inaction. And extending that analogy to the present case, by not adjudicating the matter, the court has taken the side of the president because the president is the one who is being accused of violating the Constitution. And if you sit there, then either you are saying, well, it's okay for the president to violate the Constitution, or if the president is not violating the Constitution and you don't want to tell us, or something else. Either way, it doesn't look very good at all.
Okay. Now,
look,
Prof, I'll return to you particularly on the subject of the delay in hearing the suit. Now, Rena, you have also followed this discussion for a while now. There is this group of CSOs. You remember when Domlevo was asked to go on leave? A good number of them, in the hundreds, came together and issued a statement condemning that action. They have once again issued a statement, a coalition of CSOs against corruption. And in that statement, in the very penultimate paragraph, they say that the coalition note with regret that the Supreme Court is yet to determine two suits relating to the constitutionality of the Auditor General's forced accumulated leave by the President, which were filed by Professor Kweku Asare and 9 CSOs in July and October 2020, respectively. In part, this unexplained delay in hearing these time-sensitive cases has rendered some of the issues raised before the court moot and has allowed a grave breach of the Constitution to fester in our estimation. So they are saying, blame the court too for what has happened to Domelevo. There are those who start the suspicion from this point. The time he was asked to go on leave, it was such a critical time. He was prosecuting, if you like. There was a matter that Safomafo senior minister had taken against him because he had surcharged him over the Kroll Associates contract, which he says there was no evidence of any work done. Now, when the matter, part of it went to the Supreme Court, and they were to go and inspect the documents as the finance minister had indicated, things have now been ready, which didn't appear to be ready at the time he was asking for. This was the very time his leave matter came up, and he was asked to leave the place. Then somebody took over, and that person supervised that process. Then it is time for him to come back, and then we go find, his date of birth from beneficiary 4, not where you should actually find a change of date of birth.
Thank you so much, and I hereby wish happy independence to all Ghanaians. The issues that are before us today are very germane, especially because we're celebrating our independence. That's the 64th Independence Day celebration of our nation. And we have issues that are too important and too critical. When I was reading in terms of the context, and you've created the context very well, so let me just confirm that there is no doubt in my mind, or any reasonable observer of the situation, that there's a complete nexus between the events of the surcharge of a senior and important member of the government and the processes that Domelevo have been taken through from that point up to now. Prof has serialized them, and there's no doubt in my mind that there's a nexus. It is refreshing that we have the CSOs who are getting involved and they're putting pressure and they're playing their role. But I would like the issue to be broader than that. I would like the media to take this out of the context of Domelevo and frame the issue as the fight for corruption. This is the proper context of the issue. It is not about just the removal of one officer, one constitutional officer. It's broader than that, it's bigger than that. It's about whether there is the energy and the appetite to fight corruption in this country. And this is the evidence we are seeing. I am surprised that we have a citizen today who is not getting justice from the executive, and is equally not justice. And I'm responding to the specific question that you have raised. In 1958, I refer you to the case of Balogun versus Eduse.
Right.
It has variously been said that Kwame Nkrumah was a dictator, a constitutional dictator. But these are the period that we have citizens who are purportedly Nigerians getting justice in our courts. And it's a contempt matter, but the facts are very clear for every lawyer and law student that Krobo Dusoi, who was then the interior minister at the time, purportedly singled out 4 Nigerians, or 4 Ghanaian Nigerians, and singled them out for deportation. They filed writs of habeas corpus in the High Court, challenging the constitutionality of their supposed deportation. And whilst the matter was pending, and on the day that the case was adjourned, Eduse, despite the matter pending in court, purportedly deported them. And the issue of contempt arose. And the court was very emphatic. There was no process called. There was no even evidence that the processes were served on the minister. But he was held in contempt. And he was a leading member of the government at the time. I want to see that same spirit and that same appetite to protect citizens' rights. We're talking about Domelevo today. Tomorrow we're talking about someone else's uncle and another citizen. And we have to create a system that is fair and just to everyone.
What you just said reminds me of a recent situation which is similar.
Yes.
Gary Nima Komafo was doing this case for an Indian or so. And whilst the matter was being fought in the court, this is an Indian who is in Ghana, who has a business.
That's true.
And whilst everything was going on in the court, the guy is picked and thrown out of the country. And there are some other foreign nationals in this country who have faced a similar situation, where the machinery of states is used to unlawfully remove them when they are seeking to fight for their rights in the country.
Exactly. So, so let me reiterate that.
You said you are sad. That's what you.
I'm crushed. You know, I'm crushed because I don't know. I could be the one that will be facing the fate that Domelevo is facing. This is a citizen. He's one of the committed citizens we have in this country. All he's doing is performing his constitutional duties. I am surprised that despite the clear provisions of the Constitution, and I'll take you to Article 187, that provides for the removal of the Auditor General, not so. If you go to 187, you can help me. No, of course, 187 refers to Article 46, a removal of justices of the court. So it's the same thing. Now,
Article 146.
146, yeah. 146. Is that okay? There's a procedure. If the intent, the objective is to remove Domelevo, by all means, use the procedure. This is the same procedure you employed in Charlotte Osher's case. Why is it not, whether there's propriety in that procedure is a different question altogether. But at least you are seen to be evoking the rules and the procedural. Otherwise, how are we able to tell whether an executive action is proper or not proper? We have to have regard to the rules.
Did you answer the issue of the court being isolated to also take part of the blame in this matter?
Yes, it's very clear. This matter is before their lordships. Is that okay? It's before their lordships. The institution, the final institution that protects the individual, our liberties, individual rights that are guaranteed now by letter and spirit under Article 5 of our Constitution, it is the court. And that is why there should be a sense of urgency. This is the court that must be interested in protecting fundamental rights. And they have done that in the past. They've done that even in Kwame Nkrumah's time. Our courts are some of the veritable institutions that protect the rights of individuals, even aliens, because the Constitution does not, especially when it creates terms, very generous terms, that every other person or every person is entitled to. That's what it always says. Every person is entitled to. That person, it doesn't distinguish or discriminate between whether you're Indian, whether you're Ghanaian, whether you're from Togo, wherever you are from. It is.
But what would you have done if you were in the position of the president and the board chair brings a recommendation that has documentation supporting, suggesting that the man has two different dates of birth.
But some said
we will prefer the 1961, and then which would mean that he should have left office long ago, last year. And then he also signed a beneficiary form when he was 17 years old. And in that form, he indicated that he is Togolese.
Okay, I'm going to.
What would you do if you were the president?
The president is a lawyer. So sometimes when I speak about the president, what he does or what he doesn't do, I assume certain basic knowledge that he has of the law. I'm going to take you to Article 187, clause, let me see,
Article 187, you are on the Auditor General.
Auditor General, yes. There's a provision about his age and all.
It's 199.
No, not 187.
Well, he has done.
Okay, so this article.
Recently,
so this article 187 plus 12.
Okay.
So with your permission, if I let me just take this.
Right.
The salary and allowances payable to the Auditor General, his rights in respect of leave of absence, retiring award or retiring age, shall not be varied to his disadvantage during the tenure of his office. So there's a particular provision of our Constitution that actually precludes the president from doing what he's purporting to do. His decision is unconstitutional. I think there's no further question whether this is constructive removal and whether he's not being removed from the office. That question has been answered, absolutely answered. And this provision, now, this issue about age, the Constitution says you cannot vary his condition.
His age.
His age. In fact, it's very specific. Don't vary the retiring age to disadvantage. This is what Article 187 Clause 12 is saying. Very specific. I assume the president is a lawyer. He's surrounded.
Yeah, you know.
No, I know. Well, I didn't go to school with him, so he's a lawyer, of course, very renowned one.
Right.
Yes, there's no question about that. But he's also surrounded by other smart lawyers. So, first question that an executive should ask itself, is this enterprise I am embarking on, is this supported first by the Constitution? Because your own powers are derived from the Constitution. You don't have powers. You don't go to anywhere to derive your powers. That's unquestionable. But I like to refer to a Supreme Court ruling, because matters of the Auditor General have actually been to the Supreme Court already. Okay? And it would be interesting to just, let's pay some attention to this. In the case of William Brown versus Attorney General. Now, this issue was about the budget that the Auditor General had presented to the Finance Ministry. And they purportedly changed the figures. I think they reduced some of the figures and sent it to Parliament. Then the deputy, I think William Brown was the deputy AG at the time, and he questioned the validity of that purported reduction or interference with the quantum of budget that they had presented to the Finance Ministry. And they said the information they had presented to the Finance Ministry was for their purposes only, but it couldn't be reduced whatsoever. Then the court took pains on the basis of the independence of the Auditor General that has been guaranteed, I think, by the same Article 187, then distinguished the independence in respect of three areas: financial independence, administrative independence, and political interference, political independence. This case established that this is the Supreme Court. Very soon I'm going to read what the court said in respect of this matter. In fact, on all three areas, the Supreme Court said the executive could not, under any circumstances, interfere with them.
Okay.
But that Parliament could, for instance, interfere with, if you like, redetermine the quantum of the budget that will be brought to it. Otherwise, to say so would mean that then any budget that they bring, whether it is superfluous or whether the budget is reasonable or not reasonable, then they couldn't interfere. And this is what it says. If you permit me, just permit me to just
do that.
This is what it says. It says that the court, it says that true external auditing remains one of the critical building blocks of good governance in any democratic system of government. It constitutes a key oversight accountability mechanism in public financial management in respect or in relation to persons, institutions entrusted with state resources. Hence, the extensive provisions covering the office of the Auditor General and the Audit Service, the constitutional oversight body mandated under the direction of the Auditor General to carry out this important function, the constitutional provisions under reference underpin and secure their independence, political, administrative, and financial, and insulate, this is my emphasis, insulate the service against all forms of external pressures. But I do think that the interference relates more to political, administrative operations, whilst the financial independence is a very limited. This is an authority of the Supreme Court. And which is why I am asking, if they have opportunity now to deal with the matter that Prof has brought to them, why don't they? This is their own authority. So they have firmed up the constitutional guarantee of independence of the audit service or audit service in their own judgment, their previous judgment. Very easy for them to refer to.
Okay, so you take a breather there, and let me get to Yaopong. And fortunately, he has also been doing, some cases in this respect. When it comes to Yao Safumafo's issue, he successfully, prosecuted the matter for Yao Safumafo. He was one of those in that matter. So he's not conflicted. He's here. He can represent the interest properly. He's not conflicted.
We have a duty to the whole nation.
Right. Okay. We are not presenting him as someone who is speaking and is a disinterested party. Not at all.
That is my friend.
Right. Okay. So when you listen to particularly CSOs and CSO leaders, And let me begin with a part of what One Ghana movement, when they issued their statement, they said. And then, so they referred to the Kroll Associates matter as being the beginning of the Auditor General's woes. And then they speak about, they call the leave that he was asked to take as extrajudicial, that there is no doubt that that was extrajudicial. If you read the CSOs against corruption, their statement also. So if you look at paragraph 2 of the One Ghana movement statement, they say the latest twist to the hunt, and they are calling it a witch hunt, is as ridiculous as it is a most shameless act against the Auditor General, Daniel Yao Domelevo, who was extrajudicially forced to take 167 days leave from work at a critical point in time in the case against then Senior Minister Yao Safo-Mafo over the Kroll scandal. Then, if you look at the CSOs against corruption, they too make a similar reference in their very first paragraph, and they say that the letter that the president issued comes barely a day after the Auditor General, Domelevo, returned to his post from another unconstitutional directive that forced him to proceed on accumulated leave of 167 days. How do you defend a matter like this?
Well, thank you very much. I'm not here to defend any matter. I'm just here to express my views as a citizen of Ghana, and also, as you said, I've had some relationship with some of these matters. But
you have been lawyer for the president in the petition, and you have been lawyer for Safo-Mafo in the matter we are discussing.
Yeah, well,
yeah,
we've been lawyers for a lot of others.
Okay.
We are just humbled to say that there are other cases that you'll be surprised to know that I rate them as the highest. A case I did in Nkoko District Court, but we'll talk about that later.
Okay.
Now, I think that in my view, it is unfair to say that no reasonable person will say that the matters relating to Mr. Domelevo's retirement has nothing to do with other matters that have occurred before then, and use the Safo-Mafo case, for example, as one key example to establish the point they are making. I think it may, in all due respect, also be unreasonable for one to make such an inference. First of all, it is also unfair for one to say that the executive has, as it were, established a system by which Mr. Domelevo was to be removed, and that it is a clear case of the executive not fighting corruption. I think my friend made that point. But I will read to you what Mr. Domelevo himself has said about the president. Speaking at the anniversary of the Occupy Ghana versus Attorney General case, Mr. Domelevo said the executive has been very supportive. And I said it in Egypt, that the problem about Africa is that we set up all these structures and we don't fund them. But in Ghana, I have received not everything that I wanted, but a substantial increase in support. He goes on to say, praising the government, I must say the executive, this particular executive, or the government of Nanado in the previous system, I hope you are aware, when there was a change in government, the first announcement we heard was a ban on procurement of vehicles. Is that not it? He asked. But this was the time government gave us, the audit himself, his office, the permission to buy 34 vehicles to support the audit service. We had never bought 10 vehicles in the history of the audit service before. But this permission was granted. Up to today, some people are struggling to get clearance to recruit staff, but they have. I must say it has been a collaboration, and I love it. I love it a lot. First, the legislature has been very supportive in approving budgetary allocation to the Ghana Audit Service, amount which are about 3/4 of what it was before I came into office. But the government gave us permission on 2 occasions. As of today, we have recruited from 2017 to date more than 400 additional staff just to support us to do our work. Okay. He emphasized. How can anyone, this is the man himself, making this statement. There may have been some actions or decisions taken, please allow me, that one may find, and it is within one's right to be inconsistent with what one expects. But how can the person himself say this, and yet other aspects come up, and we say that it is in the context of a broader scheme not to fight corruption by the president. Now, let's put that aside. Then we go to the issue about his date of birth and so on.
Before that, July 27, 2018.
Yes.
The Auditor General sent a petition to the President against the board chairman, Professor Edward Duajiman, and the board chairman of the Audit Service, and he complained bitterly about interference and undermining of his work. And after that, you and I know these things have played out in the public. That was long after he had said this about the government, right?
No, the date is here. You can source my news DH, Ghana News of Tuesday, 18 June 2019. What you mentioned is 2018.
Okay.
This is 2019. You can go and check. So the point is, it's fine.
These statements were made in 2019.
I mean, that is the source I have. You can go and check.
It was during the honeymoon period.
Just go and check. If what I have here is wrong, the fact that he made this statement.
But I think the follow-up.
Can I? Because I was very quiet. The fact that he made this statement has never been discredited anywhere, whether it was in a honeymoon or whether after he has impregnated his wife or had sex. That is not the matter we are talking about. This is a matter he has declared to everybody. Now I'm saying that when you go to the issue of the date of, look, most people until recently have had issues with their date of birth, to be honest with you. I mean, there was one person who was being vetted for Chief Justice, and they said that your CV in respect of your date of birth contradicts what we have known you to be. So it means that you may have been in, when you were 6 years, you were in class 1 and all that. He said, well, my mother told me I was born during the period when there was a big bang. But he became Chief Justice. So I'm saying, but when you have filled the form and you have indicated that your date of birth is 1st June 1960, then questions can be asked. And here is it that, so when people are saying that it is others who are imputing that statement to him, it is also unfair. This is his own letter, 27 February 2021. On the letterhead of the Auditor General. And this is what he says, paragraph 4. With regards to the 1960 date of birth, I noticed the mistake when I checked my information in the baptismal card. He himself filled the form, and I have a copy of the form. He put 1960 there. But he said he noticed the mistake. But for me, if he noticed the mistake, and the mistake has been corrected in accordance with law and established procedure, that is another matter to talk about. But let no one put it or impute it to others that they are the ones that have, like Professor Sari said, one person I have due respect for, that even that record may have been forged. Or words to that effect. He can correct me if he didn't mean that. But I understood him to say that SNIT record, and I have a copy here, may have been forged, and that investigation should be conducted into it. That is fine, but the man has not denied. It's the same as the EC woman who come to that, who said that, yes, I made a mistake. Everybody makes mistakes. But as to whether he made the proper correction, I think that he should take his time. These decisions are made, and even the courts make decisions, and they reverse it themselves.
Does it matter to you when these digging is done about him, the times when these diggings are done about him and are used against him?
Well, what I have seen is that it just didn't start around the time when he was coming. Letters have been written to him, inviting him to the board to have a discussion about these matters. Sometimes he didn't feel obliged. Other times he just went ahead to respond. Because of issues of confidentiality, it may not also be fair for one, but he knows that it is not just on the day he was to come or just days after
so
that this matter started.
The presidency says someone has signed a beneficiary form, and he says, I made a mistake on that beneficiary form. Someone tells the president that mistake on the beneficiary form, use it against that person, and the president goes ahead and uses it against that person without a process, as you may say as a lawyer, due process of law. Is that what you're saying? Is the presidency a court of law?
No, the first point is that you mentioned the case that Karim Macron did against the Ghana Immigration Service. The Supreme Court said that all public officers have the right to enforce the law. And that if we were to say that, in any case, that case went against my own good friend anyway. The Supreme Court affirmed the processes and the steps that the Immigration Service took and affirmed it.
No, but we are talking about the principle.
I'm coming.
Whilst the case was ongoing, Gary Nimakun was on the media. Whilst the case was ongoing, he was very unhappy that his client was being deported whilst the case was ongoing.
That is not the focus now. You've asked me about.
Exactly.
First of all, Article 58 says clearly that for me, what I found to be the most fundamental function of the executive is the execution and maintenance of the laws of Ghana. And if the president who has such a duty, and which I find fundamental, maybe not even commander-in-chief, others may argue, but because of where I stand, Article 58 states, 2, the executive authority shall extend to the execution and maintenance of this constitution and all laws made under or continued in force by this constitution. Article 199 states clearly that all public officers, and the Auditor General is not excluded, shall retire at the age of 60. So if the president on the basis of this has acted in enforcing the constitution and the relevant laws, in maintaining, now we all understand the word maintenance, we all understand the word execution, bringing into force and enforcing these laws. If you are dissatisfied, of course, like the EC situation, the person against whom the decision was made was dissatisfied, he has gone to court. So are we expecting that if the executive strongly believes in their understanding and interpretation of the law, that someone has violated the law, and it is my duty to ensure that that violation does not persist, then you say, let me go to court.
The question I ask you, as a lawyer,
yes,
with all sincerity, that
you
will use a beneficiary form, which is a supplementary form, to undo and amend original record, which is spread all over the man's record. Are you saying the president, this is the way he should enforce the law?
Something, the original
and that the president, by his own fiat, can just get up and say, I am enforcing the law. This is the way I do it.
The original record rather states that he was born on 1st June 1960. It is rather, that's a copy here. It is rather the corrected version that says 1961. This is the original record. This is the original record. It is rather the corrected version that said that he was born 1961. No. Please. And that is why, if the corrected one rather said he was born 1960, you think anybody will act on it? This is the original form that he filled. And when he said, in any case, he's also saying that he was born on Thursday. Yeah. I have some 2 names I also bear with him. But this is the form. When it were initials of other names, he didn't write any initial. But that is fine. So my point is that the original form which is here, and I believe...
Can you Professor Sari wants to come in, but can you tell me this?
No, before
can you tell me this? I want you to answer to this.
Right.
What was he being investigated for that led to going to his documents about his date of birth and the rest of them? But his original documentation as SNIT, once again, I had mentioned earlier that even on that supplementary form, the SNIT number gives you the date he insists is his date of birth. And it includes the 1961. And in fact, I have seen the very original of his form. And it is accurate to say that 1961 is what he has
is there an explanation for this social security number 3777019? We will come to that, but I want to look at briefly the accusation or the expression of unhappiness about the case pending or the cases in the Supreme Court. And I think, Prof, with all due respect, I have a different perspective. And I will not go as much to say that it is a clear indication or there is some indication that the executive or the judiciary, and correct me if you didn't put it in that, my understanding is that you are saying the judiciary have in a way facilitated a certain agenda which I have found to be unsubstantiated, not to give them level justice. And I'm saying that, be charitable if I didn't understand you well. But the point is that, Prof, you have been one person, if there's anybody who has filed or commenced actions in the Supreme Court in the past 14 years or so, then that is you. And we are all happy that you give us opportunities to assess authorities even when we are teaching our students and doing our cases. But you have been very passionate in the pursuit of these cases. So tell us, is it the case that your lawyers or yourself have written to the Supreme Court and the Supreme Court have decided not to push your case for you? In any case, if there is a delay, it is not the Supreme Court that will go searching for cases that are on the course list and be awarding to each of them each of them priority over the other. I think that we all are interested in these matters. There's one I'm also handling, which also involves the audit service. There have been some back and forth, also because sometimes the Attorney General represents the Auditor General, and the Auditor General also has his own lawyers who have filed. So these matters have to be streamlined. So I will advise that, Prof, this is a Chief Justice, as perhaps others also, who is very, very clear in his mind. I mean, when it comes to timing, this is a man who he says 9:30 he's in the courtroom. And he has, and his administration have been very meticulous in that.
But what Prof. Asari and the CSOs are raising is a fact that since the suit was filed, it has been there dormant, nothing has happened.
When you file,
and they say that delay is also to blame for what has happened, because if they had heard the case, they would have given their orders.
When you file a case,
if you were in his favor,
the Attorney General will respond. If the Attorney General does not respond, the lawyers have procedures prescribed by law. You file and bring this to the attention of the court.
Okay,
let's
hear Prof.
So if the Attorney General has filed, the next process is the setting down of memorandum of issues. It is the parties, not by the settled practice.
All right.
It is the parties that must agree and send it to the Supreme Court.
Okay.
So, Prof, I think you can advise your people. We are all interested to do so, but to blame this on the Supreme Court, I think that in my respectful view, I totally disagree.
I see. But you haven't seen cases where the Supreme Court has been proactive, so to speak, and takes the matter and asks people, go bring this, go bring that itself.
There are matters.
Whether or not it's the registry that is part of engineering all of that to ensure that there's a speedy trial.
You write to the registry and inform the registry without even writing the.
Okay, let's hear Prof. He's one of the parties, so we don't even know what he may have done. Okay, so Professor Sare, let's hear you, but let me put once again on record that the original documentation regarding Yao Daniel Domelevo, SNIT, date of enrollment, the original SNIT record, date of enrollment is the 1st of October 1978, I see here, and then the date of birth, as I can see, is the 1st of June 1961, and then nationality, I have Ghanaian on it, and so on and so forth. So prima facie, this is actually the document that should be used to judge him and not any other document. Is that not so?
Yeah, I mean, Samson, of course, you are absolutely right. And it's good to hear from my brother Yao and then Renan. I believe Yao makes several points that could easily be dismissed. So, for instance, he talks about the executive being the executive has some power to enforce the law. And if they see that somebody has done wrong, then they can act. I mean, that is almost like saying if the president finds some document tomorrow which shows that the Chief Justice is 72, he can suo motu dismiss the Chief Justice because he has a document in his possession which says the Chief Justice is 72. Or in the case of the Electoral Commission, then Ms. Charlotte Osei and so on, because there was some evidence that there were some violations of the procurement law, the president then did not have to use the procedures outlined in Article 146, and he could just have removed Charlotte Osei and the members of the commission. That's laughable. I mean, that's a proposition so absurd that it shouldn't be entertained for even 1 minute. The other point I would want to make is that the board of the audit service is not the board of the Auditor General. This is at the heart of most of the dispute that we are talking about. The audit service board is under the mistaken impression that it can control an independent constitutional officer. If you read the Constitution, Article 187, that's on the Auditor General. He is not subject to the control of any authority, not the Audit Service Board, not President, not anyone. That is something they don't understand. To audit the presidency, you have to be independent of the presidency. And you cannot create a board with 5 of the members appointed by the president. There's a representative from the civil service, and then there's the Auditor General who is also a member of the board. You cannot have a board whose membership is dominated by the president's appointment, exercising oversight over the auditor who is supposed to be auditing the president. That's a complete misunderstanding of Article 187, 188, 189. They have to be read carefully. Otherwise, we'll keep making the mistakes. It's completely wrong to think that the Audit Service Board is the board of the Auditor General's office.
Okay, now Professor Sari, I said you are here. Thankfully, you are on this show. So we should find out from you. When we say the Supreme Court has delayed in hearing the matter before it, we have the CSOs also complaining because they also joined the suit. 9 of them joined the suit. I am reliably informed that your lawyers sent proposed issues. The Attorney General reviewed and also sent back, like we will always do, what he felt was the proper issues for trial. And this was done in November, December last year. The Attorney General has not heard from your lawyers since then.
In the original statement of case and writ, we have issues, and the Attorney General responded, they have their issues. The point is, the Supreme Court itself has to be sensitive to the time value of some of these writs and some of these cases that are brought before them. Because if you go to sleep, the matter itself can become moot. And that's why I gave you the December 31 example.
But please answer my question directly, Prof. Please answer my question. I need a direct answer.
Hold on. Every every judge, the Supreme Court justice themselves, because I've been at a presentation where they were there and they agree with me that in the Amu case, the ball was dropped because it took too long to resolve the dispute. You cannot have a dispute about a parliamentary seat that has a tenure of 4 years and resolve that after 4 years and think that you have done a good resolution.
Yes, but the George Amu case, once again, it is fair to note always that we don't seem to remember that it is not as if the case was pending in one court and stayed in one court for 4 years, but that it had gone from one to the next. Now my question to you was, how do you respond to this? That if your lawyers had responded as far back as November, December, perhaps by now that issue would have been done with.
My lawyers have responded with written letters. All of these things are really besides the point, because the harm occurred in July. And when the harm occurred in July, the Supreme Court, as it has done in many cases, one of them is the Luke Mensah case in Sunyani, where Luke Mensah did not follow even the proper procedures. But the Supreme Court itself understood that it had a responsibility and it had to decide the issue. Otherwise, there will be bigger problems.
Yeah, no,
that is the
Prof, but the transparency is important. As I understand, the last time the matter came up before the court, your lawyers were ordered to comply with certain earlier orders, and it appears they have not complied. So, like the CSOs and yourself, it is unfair to blame the court.
The court was July, when we had the injunction case, and it was dismissed, and then subsequently we filed our issues. The Attorney General provided their own input, and then we said, look, if we disagree on the issues, let's just file separate issues and then let the court resolve the matter. But I am telling you something, these are all in the weeds.
Okay.
Because to me, this matter should have been decided in July. Once you allow the Auditor General to go on leave for 167 days, because of these issues.
Prof, my very final question to you would be that, so what do we do? There are some people who are suggesting that the civil society organizations simply issuing statements and organizing press conferences is not the way to be a vanguard for the society. You must do beyond that. This is a clear case where some members of the public think you should begin to embark on demonstrations to let the president understand that once he's voted for, it doesn't mean that is the end of the citizens' participation in the process.
Yeah, I agree. And that should have happened even in July, when the man was asked to go to leave. So we are already 5 months or 6 months behind schedule. Let me also provide a few reasons why the civil society groups and people like me are very unhappy.
Okay,
with
please
what
do that in 2 minutes.
Done.
Yeah.
One, we feel most of us betrayed because many of us look up to the president. I was a very young man when I first saw the president as the secretary of the People Movements for Freedom and Justice. And at that point, I formed a certain view of him, that he was a man who was always going to defend the rule of law and a man who was always going to defend the Constitution. So it comes as a shock that he has allowed himself to do what he has done. His legacy, to me, is permanently tainted because of this highly unconstitutional and unusual action. I cited the case of Seek Ye First the Political Kingdom, and all else would be added. Look, this issue may not be related to the removal of the members of the Electoral Commission. it may not be related to the resignation of the special prosecutor. But when you put all of that together, it paints a mosaic of a president who seems to have difficulty working with independent constitutional officers unless the constitutional officers were appointed by him. And that's unfortunate because, as I said, the issues may not be related. But somebody looking at the three things together will likely put them together. And it's, again, extremely unfortunate that it's happening.
Now,
the final point I want to make, Samson, is there are certain infractions of the Constitution where it is important that we all take off our political jerseys and put on our Ghana jersey. This is not an NPP, an NDC issue, an independent issue. This is a constitutional issue. If we are serious about having an Auditor General who is independent, is that our conception of what that office should be? That's the basic question.
Okay,
and
thank you.
So I agree with this call for demonstrations. The media should not let the matter die. This should be on until the president himself understands that.
Reina, Kofi Bento says, he says, the Auditor General was sent on forced leave, which he had not earned, and some were already forfeited. 2, he was then locked out of his office. 3, series of lawsuits against him were not even called. 4, his nationality was questioned. When all failed, he was retired forcefully when he had only few months to go. You want me to believe that this is a process that has been fair to him? Question, Reina. The One Ghana movement, for example, in their statement, they are emphatic that if there was anyone deserving of an extension in their office, this is the Auditor General whose tenure you must extend, because the government itself has proclaimed that he has helped to save specific amounts of money, millions of Ghana cedis.
Precisely so, and that is why, it's shocking. I mean, to many observers, what is going on, and this is, remember the case Occupy Ghana did, as to firm up. The provision was already there.
Surcharges and disallowances.
Surcharges and disallowances.
There were no rules.
There were no rules, but it was inactive. They were not applied. He is the very person who has been very, very, very good at this and has saved the nation millions and millions and millions. What do we want? We don't want someone who is saving the nation. And so in terms of his competence, in terms of the work he has done, it is there for everyone to see. And let me just say that today is Independence Day. So I invite my brother that when we're having this discussion, already he's shown, we want to have discussions that can help push the democracy forward and push our institutions forward. I want to refer to 2 cases, one of which the president was involved in trying to protect the right of an individual who was removed from office. And I'd like to now say that the constitutional provision in terms of removal from office of constitutional officers has now been stratified. In the case of Justice Aban's case and the Tufo versus Attorney General, where when there was substitutious means to remove Justice Apalu as a justice of the court, and when the GBA went to the Supreme Court to seek the removal of Justice Aban on grounds of morality and that he was not of high moral standing, the court didn't even address that matter. The court said we must pay commitment to the textual nature of the Constitution. When the Constitution provides clearly the means of removal of an office, these 2 cases establish that you must go by that procedure. And I found the president's action, and also I was also a young man when in the 1990s, this is the president led the Kumipreko movement and all of that. And I found that his actions and words are in constant conflict from the time that he assumed office as president until now. We want all to be inspired. Yeah, they're in conflict.
Maybe you mentioned Occupy Ghana. Maybe they are to blame for all of this. Because it is the exercise of the power of surcharge and disallowance, which many say is what has led this Auditor General into this trouble. Because this is the power that has been given him, and through which he was asking people, pay back this money, you chop this money, bring it back, and so on and so forth. And he dared to ask the finance minister to cough up how much, over $1 million in $1 million.
He stepped. I think that's
yes.
That
let me
very, very unfair.
Yeah.
Yes. The matter has gone through the court. There is a definite decision. Please, may I? There is a definite decision made on this matter. Mr. Domlevo's own documents that
he's re-arguing his point.
May I? This is a list of documents used by the Auditor General in the disallowance and surcharge in respect of which the appeal is allowed. This is the case that we were involved. The documents he attached include the agreement though signed in September 2017. It clearly states that it is to take effect, the effective date is February. You say what have I done wrong? No, I'm saying that, I'm not you, but I'm saying that.
I'm mentioning that is the beginning.
I'm responding to.
Those who say so.
All right.
We're only summarizing what you say.
Okay.
Many say.
Okay.
I'm saying that those who say that the beginning of Domlevo's problems, if he has any at all, is the fact that he was bold enough to surcharge people, including and disallowed expenditure by people, including the senior minister. All these documents here, including the allegation that there was no procurement sanctioning. This is his own document. This is the approval by the procurement agency. Again, when he wrote to Mr. Osafo wrote to him that we have the document. But because of national security issues, you may come and take copies. I can make copies of all these for you. The matter has gone far to the court.
This is a
certainly,
matter.
I'm saying
certainly we will not have a debate over this matter. But you agree that people have an issue when you say the Auditor General of the state is seeking documents for the purposes of his functions, and you tell that Auditor General that because of national security, I won't give it to you. Who else will you give the documents to?
He did not say, I won't give it to you. I'm saying the documents are here. Okay. He himself attached it to the court. The senior minister wrote that we have the document. You can take steps to come and inspect them.
Okay.
That was when? Because is it not a matter of fact that at the time the audit was going on and they needed these documents, they were unavailable? That he gave them time. He gave them time.
That is not true.
Not true as in the Auditor General was lying.
It is false. I won't say he's lying. It's not in my nature. But it is false for anybody to suggest. This is the latest senior minister wrote, 8th October 2019. This was before the disallowance was done. Where he said that other cases under investigation by Crow Associates are still conducting investigations into several other cases for the government of Ghana. They are considered as privileged and confidential information and reports which will be used in court at the appropriate time. They are, however, available at the office of the senior minister for your inspection and study. This is what is stated. It's a document that was
I need to respond to this.
Yeah, do in a minute.
Yes.
I need to hear from Dr. Abochi, who just joined us, in some 5 minutes, and then we move to the next issue.
That's fine. We can clothe Yaopong is here very, very forceful in his.
Don't plug
He's here very forceful. This is a court matter, But you can style it however you want it. You can clothe it and give it different names. You can say it's a cat.
Don't impute.
But if it's a goat, it's a goat. This is a very clear matter for the public. Very clear that the troubles Daniel. And this is a good citizen. At a time that we don't have a lot of heroes, that he was emerging as one of our heroes, you needed to clip his wings. Clip from one stage of clipping and trying and not succeeding.
Even when he was convicted for contempt, you didn't even come out after violating The very law that he has sworn to enforce.
We have a duty to protect the Constitution. This is a constitutional matter, and Prof has called on all of us to make a contribution towards constitutional. It is a very grave matter as to whether the security of independent constitutional entities and persons that occupy those offices, whether they have that security or they don't have that security. The presidency is not an enforcing authority. It doesn't. Presidents make executive decisions which themselves are subject to law. And the president knows that there's procedure to vindicate any decision he wants to do. I am questioning why, of all people, why he's not following the same procedure that he followed on Charlotte. This is a legitimate question.
Okay. All right. Dr. Abochi, thank you very much for joining us. If you had the opportunity of listening to three of my guests, what may be your final words, perhaps looking at moving forward? Please unmute. Please unmute.
Yes, sorry about that. I think the details have been discussed, the pros and cons. So I am just going to make one statement, and speaking from the standpoint of constitutional law, academic constitutional law, I like to generalize things for the purposes of solutions moving forward. I think that Mr. Damilovo's situation has been characteristic in terms of his entry being dramatic and his exit being equally dramatic. The time of his appointment and the nature of his appointment created an impression that he has been foisted on an incoming government. He was appointed by an exiting government at a certain time, and that creates a perception of being foisted on an incoming government that may have its own agenda. Ordinarily, that shouldn't be, because the Auditor General's position, being a constitutional body, is also a professionalized body. So it is insulated, or it is designed to be insulated from the politics of the day. But given the nature of our politics, and given the circumstances of his appointment, and the timing of his appointment, and the entry into office, it created that perception. Now, the danger with that is that because of the perception of his being foisted, he constantly worked under that pressure. That ultimately appears also to have then been characteristic of his exit. So I think it once again betrays the need for constitutional reform. Constitutional reform in the appointment process, because often the exit process only reflects the appointment process. And if we deal with the pressures and the inherent political dynamics of the appointment process, we would have cured the exit process. And I'm just saying this because it's important for us to also understand the fact that even though his work is a professionalized work, it has inherent political pressures. And the reason it has inherent political pressures is because it has impact, or it impacts the entire political establishment. If you are dealing with corruption, and if you have a body or a person who is supposed to go out there and uncover and then surcharge, you cannot divorce or dissociate that from the political process of the day. So it's important that the appointment process itself is not only bipartisan, but non-partisan. It's also important that the appointment process, therefore, appeals largely or generally to the entire political spectrum. So I think that his appointment process has ultimately impacted his exit, which has been unfortunate and which then may have consequences moving forward into the future. But it's important that the two leading parties at least create some consensus in this field, because I think as a country, the Auditor General invariably represents a useful constitutional police officer whose office we want to safeguard. But
right.
it's a learning curve,
right,
given how he was appointed. And
so then can you help us with your legal knowledge to resolve one matter? Where there is an apparent discrepancy in dates, on what basis would you prefer one date against the other?
I want to understand the question. Where there's a discrepancy in dates, which dates?
Where there is an apparent discrepancy in dates, and we are talking about Damilovo here, the date of birth.
Okay.
On what basis do you prefer one date against the other? It may be a rhetorical question, but it has an answer.
Well, again, the simple principle rests on discretionary power, and the principles for the exercise of discretionary power are out there. The Supreme Court recently reiterated them in the just ended case, whose decision came out, I think, on Thursday, and so that matter has been resolved. But an administrative entity must make decisions on the basis of certain variables, and so where there's a conflict between two dating, and these two dating all belong to state agencies. A party making the decision can decide to choose between the two of them, which one he thinks is more convincing or which one he thinks is more accurate. But that decision or that selection invariably must be dictated by the principles for the exercise of discretion. In other words, we must be able to justify why one is preferred over the other. And in order to make a decision which is unquestionable, invariably the courts are the best places if we think that there's a challenge. We think that we want to challenge a particular.
So the president has abused his power in this respect.
No, I don't think so. I don't think on the face of it. Now, let's be clear. The power to appoint invariably has the power to dismiss inherent.
No, the president has not done a dismissal. The president has issued a letter saying that he has been informed by the board chair that Mr. Domelevo should have retired last year. So he's simply asking him to go on leave. He's not dismissed him. He's simply asking him to take his retirement, thanking him for his service. Question is, the letter bases the retirement on the choice of date of birth that has been presented to the presidency.
Right. So, and I understand your point. Your point being, why must there be a selection of one and not the other? And I'm indicating the general principle, that the general principle is that when a decision is being made between two options, that has to generally be based on the principles of discretion. Now, in applying the principles of discretion between two competing documents or two competing data from two different state institutions, an administrative body or an administrative entity or an authority of state.
Let me add this to help you to get this final. There are no two documents from two different institutions. Yao Domelevo has his SNIT enrollment document. The very original contains the date 1961. Then the chair of the audit board uses a beneficiary form that he signed to vary this date. And the president takes the beneficiary form as the basis, what is found on the beneficiary form, prefers that as against the document that one may say is prima facie what it ought to be.
Invariably, okay, so again, it may appear to be an exceptional case. And I think the point I was just trying to make, so if it's not from two different entities, but from one entity, whatever the competing data is, the choice made must be made on the basis of the objective exercise of discretionary power. And I think you're trying to drive home the point, the fact that if the entry data, which is the data that captures the biodata of the person, the information that captures the biodata of the person, as opposed to a form which was filled to, say, claim benefits for someone or to guarantee something for someone, your argument is that ultimately the entry data, which is about the entry biodata, should be stronger. Ordinarily, that's correct. The entry biodata should be stronger. I guess, and have to be honest about this, and I think you are correcting it factually, I am not fully in possession of all the facts. But if what you're saying is the case, then obviously, yes, there are questions to answer on the basis of why there's a preference for one and not the other. Ultimately, however, whatever decision is taken, whatever decision is made, on the basis of Article 23, which is the administrative exercise of discretionary power, it must be fair and candid. We have to show that there are no preferences, there are no subjectivities, there are no biases, etc. But in the absence of that, of course, whoever exercised that decision will have questions to answer. The whole controversial character of the relationship between the Auditor General and the Audit Service Board also unfortunately feeds into all these allegations and all these suspicions and makes matters complicated. Because otherwise, on the face of it, one will expect that when these decisions are made, they're informed by good faith, and so people don't ordinarily question them.
Okay. Thank you very much, Dr. Bochi. We take a break. When we return, I read your messages on this subject, and then we attempt briefly to look at what has happened in Parliament. And the minority in Parliament feels that it is under siege. It says it is very disturbed and that it has never had such a difficult time in their life like now. We'll be right back. You're welcome back. This is NewsFile. It's your most authoritative news analysis platform. And here on NewsFile, we put Ghana first. So some of you have sent in some messages, and I'm going to share some of them with you, beginning with Kwame. Nana Kwame says, don't be marveled as to how Domelevo's personal data at SNIT was leaked to Facebook. And for that matter, the Audit Service Board, Professor Sari should not be surprised. Isn't Mr. Osafumafo's son a director or management member at SNIT? Didn't Domelevo investigate his father and discovered some wrong that went to court and so on and so forth on the Kroll associate? Okay. So, yeah. Then Togby, okay, let me read a couple from here before. Togby Ngoire Fiaga. That name, always difficult to pronounce. It's too long, so I'll read just a portion of it. It says, the truth is, considering the rancorous nature of our politics, the last-minute appointment of Domelevo by the president at the time itself was wrong, particularly knowing that a new president had been elected and that such actions may have consequences. Any analysis of the issue ought to start on that note. Okay, so your point is noted. Then, those of you tweeting, A.B. Mensah says his wings had to be clipped like that of the special prosecutor Martin Amidu. Collins Little Tete says his appointment came in as a mole being planted in a setting regime. Emmanuel J. Bequin says no true patriot will ever defend Domelevo's sacking. Big Boy Pure, it's not, I do not have any qualms with Domelevo's prowess, but if he is due for retirement, the right thing should be done. Honorable Will says Mr. Daniel Yao Domelevo was forced to retire by the president. During the vetting of the special prosecutor, it was unraveled that Martin Amidu was above the retirement age, yet he was approved by the president with all constitutional backing. How can I understand this? Okay, so thank you for those messages. Let's go to Parliament now. Let's see how quickly we can deal with that matter. The minority feels that it's under siege, and they have issued a statement. The NDC, as a party, also issued a statement. They had an emergency meeting yesterday. They also issued a statement. All of that on the back of attacks at the minority, particularly one also coming from Sami Jemfi, the communications officer, calling them people who have betrayed the party and are not in touch with Ghanaians because of the 3 people that were approved whose appointments were in question. Once again, this show is brought to you by Bank of Africa, strong as a group and close as a partner, MTN everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa, Duraplast, where Duraplast goes, water flows, heavy mosquito spray and coil, pleasant on humans, tough nightmare on insects, and Napa Food, it is tasty. DBS Industries, Robert & Sons Limited Optical Services, your comprehensive eye care services provider. On this note again, let me go to the Google man, Professor Sari. So, like I said in my introduction, people have been excited that we have a parliament that is, if you like, hung, split right in there. And so when they were vetting the ministers and the manner in which they went about it, and eventually told us that 3 of them had issues, it was expected that not all of them would be approved, and that there was a sense in the public that one particular person didn't deserve to be a minister, and yet all of them went through. Now they are in trouble. They are being accused of taking money. Some say, well, they are broke in opposition, and so they have debts to pay, and all of this. So they've not been happy at all. I'll read some of their statements to you. But what do you say?
Well, you know, such unhappiness, it's part of the political process. People are allowed to express their opinions about what happens or what is happening in Parliament. So I don't see any problem with the unhappiness. And I dare say the unhappiness is probably not limited to people in NDC. There may be some in NPP who are also unhappy. Perhaps they are not able to express their feelings as loudly as some of those in the NDC. Such unhappiness happens everywhere. Even in the United States, it's happening. You know, within the Democratic Party, there are people lobbying. You know, we have the Bernie Sanders wing of the party, and then the moderate wing of the party, and so on. And each wing has a list of people that they want to see in Biden's cabinet. One person, I believe, has been withdrawn because the senators signaled that they were not going to approve of the nomination. So these are healthy. I really see nothing wrong. And I'm going to allow the politicians to comment more on that. But allow me to make a few points that I wrote down while watching one. I only watched one of the vetting, and even that I watched because I was watching the Supreme Court proceedings, and then there was a break. And so the only thing I could watch was the vetting. It was unfortunate that that was also the time that Madam Hawa Kunsin was being vetted. So by accident, I happened to watch hers. What is Parliament actually doing with vetting? To me, they are evaluating a person's qualification, a person's temperament, a person's policy grasp, a person's policy preferences, and whether or not there are any conflict of interest. These are serious issues, and as you can see from the Constitution, the appointment of a minister is a joint activity. The president nominates, Parliament approves. Parliament is not supposed to rubber stamp whoever the president brings. They should test each of those things that are enumerated. And so it imposes burdens on everyone. First, the nominees have to be honest to themselves. If you are a nominee and the president appoints you to a position that you don't have the expertise, you owe a duty to the president to deny, to reject that nomination. So for instance, if I was sitting here and the president called me and said, Prof, I want you to come back home and be the Minister of Fisheries. I'll tell the president, all I know about fishing is I eat fish. That's all. I don't know anything about fisheries. I'll be a disaster. And I don't want to humiliate you by going to face these parliamentarians and they ask me questions and I look lost. So the nominees themselves have to be a little honest with themselves and not expose the president to, you know, this type of ridicule that comes in when they appear before the committee and they don't know what they are talking about. Likewise, the president also has the duty to do some screening so that people that he sends to Parliament are not exposed in the manner that some of the ministers, I think, I want to mention her name, Madam Hawa Kunsin was exposed with some of the questions that were put to her. Finally, the MPs themselves make an oath to confirm only qualified people. And to me, it's somehow a violation of the oath to actually confirm someone knowing that that person is not qualified. We have to treat the country with a little bit of seriousness. So if a person shows up and by his or her answers to questions that are asked of her, show that he has no clue what the ministry that he or she is being assigned to, what they do, then by all means, the person should not be confirmed.
Thank you very much.
Finally, let me make a final point. Samson, I want to draw a distinction between the way we appoint our ministers and the way ministers are appointed under the Westminster style. In the Westminster style, Parliament has no role. The Prime Minister chooses ministers from among members of Parliament. And as a result of that, the ministers can be reshuffled very easily. Our approach mirrors the American approach, where ministers are vetted for specific positions. So the only thing I want to add and I want to emphasize is we must start thinking about the proper role of reshuffling in our system of appointing ministers. If I'm a minister who has been vetted for fisheries, can the president then reshuffle me to the Attorney General's department? I think not. And we need to really resolve that.
If someone who has been vetted for fisheries is a lawyer, duly qualified, the president should be able to reshuffle them to the Attorney General. The Attorney General's ministry is one that the Constitution clearly circumscribes.
Because you've not been vetted for the position of Attorney General. You've been vetted for the position of Ministry of Fisheries.
Okay, thank you.
If you were nominated for the Attorney General's department...
Sami Gyamfi began all of this, and if you follow the opposition, if you like, opposition, pro-opposition media, they have taken them to the cleanest. I'm talking about the minority members. They ask the question, how on earth did you end up supporting the NPP who would vote for the nominees anyway? And that's a presumption that may not be exactly accurate. How did you support them to vote for people that you gave the impression to the whole world that were not qualified? You know, Sami Gyamfi said, the betrayal we have suffered in the hands of the Speaker of Parliament, Abambabwin, the leadership of our parliamentary group, particularly Haruna Idrisu, Muntaka Mubarak, and dozens of our MPs. It's what strengthens me to work hard for the great NDC to regain power. They brazenly defy the leadership of the party and betray the collective good for their selfish interest, and we must not let them succeed in their parochial quest to destroy the NDC, the party that has done so much for them and all of us. The shame they have brought on the party will forever hang like an albatross around their necks. Then he brings in what he thinks people were expecting generally, and these people have failed. And then you hear the commentary around, you know, imputing corruption, among others, and they have been forced to also issue statements.
Okay. Something, under normal circumstances, because of my loyalty and commitment to the NDC party, I desist from making public comments that denigrate or that tend to tear the party apart. But insofar as some actions of leadership, I don't know how it came about. But insofar as some actions tend to have future repercussions on the fortunes of the party, I think I'm entitled on it. It's on that basis that I'm going to make my submission. And I also make my submission as a grassroots person. I may be sitting here and speaking law with my friend Yaopo, but fundamentally I am a grassroots person. So I'm as head as any of the grassroots people. At a time that we were building momentum, you know that the event of 7th, in the morning of 7th, or if you like, midnight of 6th of January, the NDC Minority Caucus had created some semblance of unity and togetherness, as we have seen in other places. You know, even the, and I expected that same solidarity to exist going forward for two reasons. Because I believe so that it is not just the NDC minority or people who are affiliated or people who have interest in NDC affairs who are interested in what has happened both on the 6th of January and then on the 3rd of March. There are, if you were to do a census or some poll, a survey, okay, to find out how many Ghanaians would actually have wanted some of the nominees, like Howard Kumisen, to be dropped, you're going to have a resounding majority number of Ghanaians, because there are many Ghanaians that are actually looking for substance. They want their material well-being to improve, and they vote because of some of these things. The least they can have is to have someone impose on them who doesn't have, from what appears publicly, grasp of basic issues. I was questioning, because look, I'm from a Greek background as well, so I know how the industry can be complicated, even how to deal with the local population. There are issues of conflict within the fishing community. She needs the skills of ADR, you know, authoritative, you know, she needs to be able to engage. The fishing sector is one area where you have, for instance, many conventions, international conventions and instruments and bilateral agreements because of straddling waters and the manner in which the resource is distributed across
Among
borders.
those that were slated to be rejected, she got the highest votes.
Yeah, so that's thanks for bringing my attention to that, which is surprising. So now the base of our party is hurt because of two reasons. One, the minority itself wrote some thesis and theorized why certain people should be rejected.
That's right.
That was within a week. So you had a principled position on the basis of qualifying criteria that you think you designate these nominees as being incompetent or lacking in competence or merit, whatever it is, to be approved to be ministers of our state. Then within the week, you make a U-turn. That's problematic. It smacks of inability to stay together on course or to stay on principle. And that hurts. Look at Donald Trump. Look at what Trump did on the same seat when he vandalized America's democracy and the Capitol Hill. Okay. His people still stood by him. You know that. The Republicans still stood by him. He got votes. He was not impeached despite that. That's unity. But we, as a party now, are in a very difficult situation. And no one should think that 2024 is some distant future. It starts now. You build momentum immediately after the elections and build it. We were having public goodwill, good faith from the Supreme Court. If we were to accept it, no matter what the outcome is, then we move to the base, and then we are doing well in Parliament, and we're holding the executive to account. One of the problems we have always had throughout the fourth Parliament has been the overbearing power of the executive. So this was the only occasion that we were thinking, and many Ghanaians of goodwill were hoping that we could not only this, because, and this frightens me. So going forward, what kind of bills are going to pass through Parliament? What bills? Because does it foretell the future that we're going to have the Japas rear their ugly heads again? Is that what is going to happen?
Why do we appear to discount the fact that for a number of those I think they were sworn in yesterday, last night, about 28, 29 of them.
Yes.
For a number of them not to receive consensus,
Okay.
and to be subjected to vote.
Okay.
You don't think that is also significant? That you have become a minister not by consensus of your colleagues.
That's a good point to raise. But I need to say that it depends on how strong you are on a principle. Once you believe on the basis of qualification criteria, then so be it. Otherwise, we now create this precedent that whoever the president nominates becomes a minister. That's problematic. True or false? You would expect that the president himself would have done his background work based on he's been president for 4 years. He would have practical knowledge of the competence of these people. He would have worked with them. There are always supervisory notes from the chief of staff who is doing well, who is not doing well. So I'm surprised. And if I want to comment generally on the list that he has submitted to Parliament, you notice that there are people who are very loyal. I think the president just went for loyalty, besides any other thing. I know, I have friends who are MPP. If they wanted...
Educhum Education
I have friends,
Ministry.
look,
hold on. Educhum Education Ministry. Is it a question of loyalty?
Perfect. Oh, perfect.
Is it loyalty?
No, I mean, he's a perfect choice for the area.
Attorney General Godfrey.
Yeah, of course, maybe my statement may be sweeping, but that is just to say that, but loyalty, competence, that's a good thing. Yes, sir.
All right.
A combination of competence and loyalty. But some of them clearly, as we have seen in the output, the vetting output, it leaves no one in doubt as to whether they should be there.
So let me ask you.
So I think it's a lost opportunity. My conclusion remarks on this are it's a lost opportunity, and I don't know how they're going to survive or revive the spirit that the nation felt going forward, and what will happen to bills that are going to come before them. And finally, let me say that I like comrades to calm down. We cannot be writing letters to each other. This shows that there was no strategy going into the matter of the nominations. And they should learn from their own example that when they showed resilience and strategy on the seat, they won. And I want that to happen. The honorables, I would have gone for their heads. But there has to be changes.
Okay. Now, let's listen to two of the people in the NDC from Parliament and out of Parliament. Two people. Let's listen to what they have to say.
I never voted any of them, and if they bring them 1,000,000 times, I'm not going to vote them. I don't have anything personal against them, but I think that they are each unfit to be ministers of state. Some of them lied under oath, so I can understand the pain, the anger of our rank and file. If they didn't love the NDC, I don't think they would be worried. They loved the NDC. Some suffered for the NDC. We are members of Parliament. I was scandalized that some of them got more votes than the number of MPs that the NPP has.
Commission obtained 60%.
24 of our members voted for our commission. Right. It's absolutely preposterous, and I find it extremely difficult to comprehend.
So you have betrayed the party. Is that what it is?
Well, if we failed to do what the rank and file of the party expected us to do, we should not be run away from blame. I have had people who call and express their anger, particularly a lot of the platforms. We just need to exercise patience. We just need to talk to them. I have received a lot of attack. Maybe perhaps to a very large extent, maybe my conscience believed that I wouldn't do such a thing. But I have had people who call and express their anger, particularly a lot of the platforms.
Sami Demfi expressed an opinion. It may go down well with others and not everybody, but he expressed his opinion and he said it as it is. Personally, and I think that I speak for a lot of our people, we are all not very happy with what has happened in Parliament. We think that our parliamentarians could have done better. We think that the parliamentarians should have weighed or measured the temperament and the tension within the system, and has maybe modified their way of handling issues. The parliamentarians will have to look at their strategy again and see the best way to balance doing their national work in Parliament and also assuaging the feelings and the pains of our rank and file.
So you had Murtala Muhammad and Baba Jamal there. Now, the reasons that they had issued for not approving, agreeing on consensus for these three nominees, Hawa Kumsin, Dr. Uswe Friye Akoto, and Kojo Opon Nkrumah. Hawa Kumsin, the fourth reason was that the minister-designate displayed an alarmingly abysmal lack of knowledge on the sector she was nominated for, making her unfit for the portfolio and therefore untenable to secure the approval of the members of the NDC caucus. Dr. Uswe Friye Akoto, they had a number of issues against him, and then the fourth issue, they said the minister-designate was particularly discourteous, downright condescending, and offensively arrogant in his appearance at the committee, which is not the kind of attitude expected of a public servant. But they had other substantial matters which was not about his conduct. They said he was untruthful under oath about his directive ordering GPHA to issue a license to Fruit Terminal Company Limited, and how his actions could lead to a 50 million US judgment debt. Kojo Opon Nkrumah, they had a number of issues. They said the minister-designate for information, now he's minister, was not the least candid with the committee on the multiple infractions of the law leading to the Bank of Ghana's revocation of the license of Oval Microfinance, a company in which he was 83% majority shareholder. He failed to admit ethical liability for the related party lending between Oval Microfinance and West Brownstone, which also belongs to him. He also denied outstanding obligations to Oval Microfinance despite the Bank of Ghana's examination report establishing the contrary. He peddled untruth under oath about the circumstances leading to the investigative journalist Manasseh Azuri Awene's relocation to South Africa with the assistance of Media Foundation for West Africa. And maybe one more of what they had against him. They said the nominee was quite evasive on his association with MX24 TV, which is owned and managed by his wife, with other family members, such as Kwabena Opon Nkrumah, serving as shareholder trustee for the parent company of MX24 TV, known as Black Volta Publications Limited, incorporated recently, 4th of April 2017, when the nominee was serving as Deputy Minister for Information. So the question is, if this is what they had to say about them, how do they turn round to give their approval in such numbers?
I think you first have to also look at the Constitution's prescription for qualification or qualification criteria for ministers of state. And first of all, the Constitution, apart from the Attorney General, who many agree, I was recently told that some people think a person who is not a lawyer can be an Attorney General. Well, that's a debate that can be made. But with the exception of the Attorney General, the Constitution does not prescribe that the approval must be in reference to a particular sector. It only says at Article 78, ministers of state shall be appointed by the President with a prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament. So the question you ask is, what are the qualification criteria for members of Parliament? So if a person qualifies to be a member of Parliament, then he qualifies generally to be a minister of state. So, and I put some note down in reference to Hawa Yakubu. And I say that
Hawa Kumsin.
I wonder, a lot of people make that mistake. May her soul rest in peace. Hawa Kumsin. It looks like the main reason that you spelled out was about the fact that she did not exhibit knowledge in the sector. So I put down, so not that she is not competent as a minister of state, but she did not exhibit competence to be in that sector. And I think that if you go through the constitution, therefore, that it means that all that Parliament needs to do is, or the appointment committee, is to ascertain whether or not first, under Article 94, the person is qualified to be a member of Parliament. If he's already a member of Parliament, of course, that does not mean that then he must just go through. There are certain things that you can look at for. But obviously the Constitution didn't state that moral standing should be a qualification. It is only in reference to judges. The Supreme Court judges, the Chief Justice, that is, moral standing is specifically mentioned as well.
But the qualification to be MP includes moral turpitude.
No, not that I'm aware of.
It is there. It is there.
Okay,
it is there. So moral standing is part of it.
Yes.
Yeah. And again, if you have been convicted of an act of dishonesty or something like that.
But there are exceptions under the same 94 that if you serve your term and, I mean, some additional term, that disqualification criteria is taken away. Okay. So when you are vetting a person, or the Constitution uses the word approving of the nomination by the president, you just have to look at whether or not he is qualified to be a minister of state. Of course, the president may have presented the person to be in charge of a particular ministry, but that is the fact that the president also has the power to reshuffle, because you need not vet the person for that specific ministry or sector alone. So that answers perhaps the issue that Prof is. But I think the NDC must also remember that, but for some members of MPP to have voted for their preferred speaker, their preferred speaker wouldn't have been voted. At that time, they were very happy, and I was happy. I said it openly, that this is what we expect, that people are sent to Parliament not just to represent the party, but they are the people who voted for them. So are we now saying that Mr. Haruna Idrisu's people and his people, I don't know whether he voted this way or that way, are we saying that they did not vote according to what their people want, or the side that their people wanted them to vote for? Are we saying that they did not listen to their own constituents and voted against the wishes of their own constituents?
That's exactly what they are saying.
Well, as it stands now, we have heard a few in Accra and other places expressing this view. I have not heard.
They brought the report. We didn't ask them to do that.
Yeah, so that's why I'm saying that report.
For how Kumsi, let me read further.
Okay.
They said the minister designate for Fisheries and Aquaculture Development could not provide convincing grounds for the shooting incident during the voter registration exercise in Kaswa on 20th July 2020, even though we acknowledge her belated apology for her reckless, dangerous conduct. Furthermore, claims of an ongoing investigation by the police and did not come across as credible, considering that there has been no update from the police for more than 8 months after the unfortunate incident. Our checks also point to the fact that she has not provided any statement to the police as of yet. The nominee confirmed the identity of close associates who have unleashed a reign of terror on helpless political opponents in the pursuit of their narrow political ends. Well, so they say she's unfit.
So, I mean, you mentioned moral turpitude. Article 94.2 is about the person who has been convicted of high crime under the Constitution, treason, offense involving dishonesty, fraud, dishonesty, and moral turpitude.
Exactly.
So the person must have been convicted first. If the person has not been convicted of whatever crime we can call moral turpitude, you cannot use it. That's my view.
Okay.
Now, so in actual fact, there are concerns that must be raised. People may not be happy with the performance or otherwise. But if you look at this lady, she was given one of the important flagship programs to manage. I mean,
Special
the ambulances and all those ones. I think people are, to some extent, satisfied. Yes, we all sometimes face issues when you are going to face a panel. I mean, no matter how intelligent you may be, even going to the court, you go to the Supreme Court, and all your preparations that you have done may evaporate.
They can throw you off completely.
When they start throwing the questions at you, it even happen.
No, so what are you saying? What are you saying? That the vetting exercise is what? Is to rubber stamp what the president presents?
What I'm saying is that, in fact, this last vetting, as I can recollect, has been the most rigorous since 1993.
To what effect?
The effect is that at least it has brought out matters, some of which I say that were not within the remit, but it has been exposed. The end should not necessarily be that the people should be rejected, unless it violates the Constitution. Like some have been rejected in the past because they were not even a registered voter. I think one person was, if I can recollect. But that aside, it is so important to bring these matters up, conflict of interest. There are other remedies.
Okay.
Where, for example, there's conflict of interest and the person was a minister. But just to say the last thing, that Parliament itself has the tool to apply. When a person, again, you know the power of censure. When a minister of state violates any of the, his gauges in conflict of interest or anything that Parliament can apply as being a ground for censure, Parliament can do that. Unfortunately, we did not in the past see that Parliament had ever applied such a tool. They could have done an articulated tool. Parliament, by resolution supported by votes of not less than 2/3 of all members of Parliament, pass a vote of censure on a minister of state. So if you are accusing them now of engaging in certain acts for which you could have brought or you could have invoked this very important power or authority, you didn't. Of course, crime has no expiry date. But you wait till the person comes before you and then you want to use it beyond the threshold that is established under, in my view, Article 94, then it may not also be unfair. I think they should continue to have faith in the leadership. For me, they have done very well. One good turn deserves another.
Let's get to Dr. Abochi. And, there are people who are really very angry. If you monitor social media and elsewhere, and I decided to do something. Sami Gyamfi's statement, I went to his page on Facebook. And on his page alone, you could say, aggregating the people who had come there to comment and everything, you have almost 1 million people on his page alone. In excess of 1,000 people have shared his comments, meaning they like it. Now, all other platforms, you can imagine how other people are also feeding on it on various places, and even the publications. You have heard Kwesi Pratt very angry that this is not what we voted for. We thought that this will be a parliament that will hold the executive in check. And if a parliament that is split right there in the middle cannot, then we are doomed. What do you say?
Well, I think, first of all, we tend to underestimate the back channel activities that go on in Parliament. There are a lot of trade-offs and a lot of political maneuverings that go on behind the scenes in Parliament, and these tend to ultimately influence outcomes. It's important, first of all, to appreciate the fact that the NDC sees itself as a government in waiting. It is hoping to become the government in the future, and in that respect, therefore, things they do today, they invariably have an eye on tomorrow. Now, this mixed together with the political maneuverings and the trade-offs implies that the members of Parliament of the NDC may themselves be taking decisions today, expecting that whatever dynamic Parliament turns out to be in 2024, should they be in government, they will probably have to fall back on Parliament, given the precedents that is set today. Now, I also say this against the background, the fact that the members of Parliament the people who appear before them, I'm talking about the nominees, a good number of them are members of parliament. So these are colleagues. So in spite of the optical things we see on TV, in spite of the rightful questions that are asked and the probings that are engaged in, ultimately these are colleagues, and they will be happy, or some will be happy to exact political revenge on the cameras, but when it comes to the decision making, they invariably may pass them. Similar things happen in interviews, where you may have very probing questions asked at the interview itself, but ultimately a candidate is allowed to go through because in the end, the questions that have to be asked are asked. People have exacted the revenge they want to exact, and they will not necessarily obstruct the process. So I think what we're seeing reflects those political dynamics, a lot of which go on behind the scenes. That is where members of parliament are friends. That is where members of parliament fight for the bottom line. And that bottom line is to remain in parliament, and then for ministers to ultimately be given the nod to become ministers. So it is a real politic, and the real politic dimensions of things invariably tend to defeat principles. But it also reflects one thing, and I think the reaction reflects one thing. What it does reflect is to also see a certain schism gradually developing between the base and the members of parliament. The base may have their own expectation, and the fact that there is this rather radical reaction reflects the fact that the base, or rather the members of parliament, are not necessarily in tune and in sync with the base. But this may also then reflect a larger issue. Under what circumstances should members of parliament consult the base? In other words, are there decisions that are purely driven by principle, that are purely driven by certain high-level thinking that the member of parliament in whom confidence is reposed by the electorates, by reason of which he's been elected, is allowed to exercise judgment? If the member of parliament is allowed to exercise judgment, then presumptively, the member of parliament is not entitled or is not obliged to go and consult the base. So under what circumstances are members of parliament given that prerogative and given that presumptive knowledge to make decisions without necessarily consulting the base? And under what circumstances must members of parliament consult the base? Now, given that our democracy is developing and we're still not that very sophisticated, I think that there could be consequences where there's a clear case of schism between members of parliament or between parliament as a body and the base. But it's a learning curve again, and I'm sure given the development now, we're going to probably see all kinds of tendencies and consequences moving forward. But having said this, let me just say that it's important for us to also appreciate the whole essence of vetting. So the vetting is designed to, as it were, check the nominee, the potential nominee, but benchmark the potential nominee against clear constitutional standards. And the constitutional standards, if you look at the Constitution, clearly vetting is designed to elicit three things.
Dr. Abuchi, your line is breaking, but you are taking us back to what you told us earlier when we discussed this issue and sought to find out what the essence of the vetting at all is, if there was any importance to it. So let's try again. Let's see if we can hear you clearly. It is to do three things. What are the three things again?
So the three things are listed were the fact of capacity or competence, and then capacity or competence, and then credibility, and then finally eligibility. And I'm sorry for my poor connection.
It's okay.
Now, the issue of capacity or competence, so I think that has been mentioned by one of the panelists, the fact of whether the person can undertake the functions of his office. And the functions of the office, I think it was mentioned earlier, Prof mentioned earlier that when people are being appointed, when they are being reshuffled, they must go back to Parliament. I respectfully hold a different view. Now, if you pay careful attention to the Constitution says the ministers of state shall be appointed subject to the prior approval of Parliament. So it is ministers of state. Everybody who is appointed is a minister of state. He's not a sector minister. The sector is only indicated for purposes of making the work of Parliament easier in terms of Parliament having to ask the right questions. But the appointment itself is a generic appointment. So all appointees to the positions of ministers, they are all appointed ministers of state on the face of it. That means that you are appointed a minister of state and you are qualified in principle to occupy any office. And so when you are appointed a Minister of State for, say, agriculture, the sector of agriculture, and you are vetted for agriculture, of course, you are not going to, the president is not going to lie to Parliament. So after that, the Minister of State will assume the office of agriculture. But if the president decides to change that person from agriculture somewhere else, the president doesn't need another parliamentary approval, because the appointment is for qualification as a minister, qua minister. You are appointed as a minister who qualifies and who is competent enough to sit in the position of in the ministerial position across the board and across the spectrum.
But the nomination doesn't go wholesale, and the vetting is restricted to a specific portfolio.
And that's the point I made. That is just operational. That has been by practice. That is not constitutional. The Constitution doesn't restrict the appointee to a particular ministry, but it is just parliamentary operational processes. It is just the relationship between Parliament and the executive that has seen this practice, where every ministerial nominee who is nominated is actually nominated for a sector. But the president can nominate someone to go for vetting without an attachment to a ministry. So a person can be appointed as a Minister of State. He goes through the appointment.
All right, we lost Dr. Abochi there, but if once we establish contact with him, I'll put my very final question to him, then we will be able to take a break and return to look at the election petition judgment. Yes, I will take a break right now and return. I have some messages I'll read to you. Many of you are still sending messages on Domelevo's forced retirement. We'll be right back. You're welcome back. This is NewsFile, it's your most authoritative news analysis platform. It is brought to you by Bank of Africa, as strong as a group, as close as a partner. MTN, everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa. Europlus, where Europlus goes, water flows. Having mosquito spray and coil, pleasant on humans, tough nightmare on insects. And Napa Foods, it's tasty. DBS Industries, anything roofing, looking for durability, that's where to go. Robert & Sons Limited Optical Services, your comprehensive eye care services provider. And talking about Napa Foods, just reminds me that my friend sitting here is waiting for Alaji's wife, Wachi. And we are all waiting for it. Right. Okay. Of course, Independence Day, and the reason we are all in Africa where beautifully. Thank you all. And as you know, we end today's show at 12:30. And so I'm not in a hurry at all to go for Alaji's wife, Wache. Right. So just one or two comments from some significant commentators. CDD's Kojo Asante says, does Yao really appreciate that we are talking about an audit, not some document sharing exercise? There is a reason why audits are done within a period. Otherwise, people can find clever ways to cover their backs after the fact. Nobody seems to appreciate the fact that Mr. Domelevo is an auditor, and the rules of audit must apply to everyone, including the minister or the chief of defense staff. Domelevo was victimized for doing his job, nothing else. Then, I'll say he's my cousin. Then Manasseh Azori says that, tell Yao, everybody is saying tell Yao. Tell Yao Pong that it is untrue when he says the information was made available to the Auditor General during the audit.
I didn't say so.
It's false.
I didn't say so.
Yao Pong said the letter he referenced was dated October 2019. By then, the audit had been completed, and the Auditor General had by September served the notice of disallowance and surcharge on the senior minister and others. This notice was issued after the audit had been completed. What is the nature of the evidence of work done that the Auditor General, who audits the Presidency, National Security and Defense, and Interior Ministries, cannot have? That is a question. And then he attaches the Auditor General's letter he wrote that time. So, Doc, I was asking you the very final question, whether we should do something else or we should continue to do this. If, after all, the nominees will be approved, then why waste the president's time? Why waste all of us our time in the House? And listening to the debates, when they were approving them, the majority members appear to simply say, everybody doesn't have any problem. And some of them actually say, this is a woman, she has children, and so on and so forth. Let's go ahead and approve them. So like Professor Kwekwasari said, why don't you adopt a method where you give the president a free hand to simply do it? We are in March. It is now that the president is getting the compliment of his government.
I have been, Samson, I'm sure you will know my position on this. I have been critical of Parliament in terms of its sub-optimality since 1992 to today. So I'm the first person to criticize things Parliament do that I think are below what they were set up to do. The political reality of things can hardly be debated, and so it's difficult to change them. Parliamentarians are political beings, and so as I indicated, the political maneuverings and the back channeling of things, those are things that happen in every parliament across the world. However, it is important that a certain degree of quality be injected into the process. And so if MPs themselves, or if the members of the committee themselves have identified certain clear weaknesses of certain MPs, then passing those MPs can only be justified if they show that there are superior reasons over and above those defects. Let's be clear, no nominee can be 100% clear of all the three things that are listed: the capacity, the competence, and the credibility. No nominee can be 100% clear. Every nominee will come with some weakness or weaknesses or the other. It's important that Parliament then does the balancing act. The question is, in deciding whether to pass one nominee against the other, and in deciding to pass that nominee, weighing some variables higher than the other, what considerations did Parliament make, and whether or not the considerations Parliament made are overall justifiable, given the balance of factors of strengths and weaknesses for and against candidates that were presented before the committee. But the reality is, look, these things are heavily steeped in politics. I mean, these are political considerations, so you can't subject them to the legalities. The legalities are whether the person has been convicted before, whether he qualifies to be a member of parliament, whether he's a registered voter. Those are the legalities. Once the person passes the legalities, the others are political considerations. And for political considerations, the variables are highly subjective. And those are the ones that are difficult to negotiate or to, as it were, criticize as we sit outside of Parliament. So the most important thing, particularly for the NDC, is to deal with the difficulty of the base and the MPs disconnect. If you have a disconnect between the base and the MPs, then it can actually have serious political ramifications, some of which may be in the character of negative votes against you at the next election. And those are the worries that some of them have at this stage. But otherwise, those are political wranglings and maneuverings, and you can't subject them to the legalities.
Thank you very much. Clement Akapam says that the disquiet from the NDC on the approval of the ministers bring to the fore a bigger issue of the relationship between political parties and their caucuses in Parliament. My view is that MPs must be independent of control and direction of their political parties, but dependent on the ideals and ideologies of their political parties. Well, you hear some people ask you whether you have politicians who have any ideologies that they can talk to you about or espouse. This is a sure way to have functioning and principled legislature. The party had an emergency meeting and called for a ceasefire and then promised that it will look into the matter. Then this statement was also issued by and signed by Haruna Idrisu, the minority leader. He said, the past few days have been the most difficult for the NDC minority caucus in Parliament following the approval of President Nana Addo Dankwa Akufo-Addo's nominees for ministerial appointees. Justifiably, the party's base and grassroots are unhappy in some instances and have had cause to reject and even condemned the decision of the House to approve the 3 nominees that went through voting. For many, it is unimaginable how they could pass the test in the hands of the same minority that secured them a Speaker of Parliament from an opposite party in the executive on the 7th of January 2021. Then he goes on to pledge their resolve to ensure that in future they would hold them accountable, and then assures that nothing untoward went on. The suggestions about people having been compromised are not correct. Then he appeals for calm among the rank and file. The very last statement, paragraph I read, he says, "We pray for calmness, even as leadership at all levels continue to offer us direction towards our coming victory. Be assured that the caucus is still the caucus of the 6th and 7th January 2021 that achieved the unthinkable feat of electing the Right Honorable Bagwing as Speaker. Let's keep the faith. May we all be measured in our utterances as we seek to rise together. God bless the great NDC." Signed, Haruna Idrisu. And he also sends a note to us to inform you that he doesn't operate any social media, is it Facebook handle? Yes, so be careful if somebody is on Facebook saying that he's Haruna, then he says he is not. All right, thank you very much. Okay, so my attention is drawn to this. Let me read that quickly. Oliver Bakavamawa says, "I disagree with your opponent's limited view of the parliamentary approval process. Parliament exercises the power to approve ministers on its own terms and on benchmarks it deems necessary to the role. If those terms are limited to only reading the eligibility criteria of MPs under the Constitution, then Parliament's role in the appointment of ministers is unnecessary. Also, if Parliament's role is limited to the eligibility criteria of MPs, then MPs nominated as ministers need not be vetted by the same reckoning." Right. So, thankfully, Yaopong is with the legal team of Nana Addo Dankwa Akufo-Addo, whose election has been upheld by the Supreme Court as valid. And Reina also, Akumperia is with the NDC legal team. So thank you once again. Now let's look at that matter. If I may start with Dr. Abochi, you may have listened to the judgment or you read it afterwards. It's just a little over 50 pages. So as compared to 2013, which was some 600 plus pages, because each individual judge wrote their opinion. This time, it is not individual independent opinions being brought together as a composite. It is a unanimous opinion. Some have suggested that something is lost by the unanimous rendering without individual judges' opinion. What do you say about that?
Oh, I absolutely agree with that. I have been extremely troubled by the practice of the Supreme Court for some years now. It's actually not for this judgment alone, but it has been the practice of the Supreme Court for some time now, where justices don't write individual opinions again. And I was actually jokingly going to write, I've actually jokingly been thinking of writing an article with the title, "I agree." The expression "I agree" has become a judicial expression where justices basically just associate themselves with the lead judgment, and that's it. It has become a practice of the courts for some time now, and it's, in my opinion, it's quite troubling, because the practice of old, where you had justices individually writing opinions, even where they agree, you can actually see a justice of the court fully agreeing with the majority, but still writing an independent opinion that they agree with. I mean, that supports the majority decision. For those of us in legal academia, this represents raw materials for teaching. In fact, we are struggling these days to get opinions that can compare with other opinions out of which we ask our students to distill not only the ratio, but to distill the commonality of the principles that bind or unite these opinions. These days, what we have is simply a case of one opinion rendered usually by the majority, whoever is writing on behalf of everybody else, and that's it. And often you don't have dissenting opinions, and the dissenting opinions too, we've lost the depth of dissenting opinions. We have referred our students to sometimes dissenting opinions, even where there are majority opinions, and we refer them to the dissenting opinions as actually the opinion that attention should be paid to. Reference is made particularly to the decision of the court in Kwachi versus Attorney General, in which the most respected Justice Taylor, as he used to be, rendered the opinion on a dissenting opinion, which has actually become the lead opinion for the law students. We refer the law student to read that dissenting opinion as an opinion that actually tells more on the principle than lead opinion. So opinion writing and the differentiation of opinion writing, even where they support each other, is extremely important for legal scholarship. And Alexander Bakio, a well-respected international constitutional lawyer of American origin, just said part of the reason why the courts are respected and insulated from the political process is because judges took what he called the ways of the scholar. The judicial process is a scholarly process. So when a judge is appointed, he's a scholar. And part of his hallmark is that he writes opinions, and these opinions are supposed to be the distillation of legal principles on the basis of which the law is developed. In other words, judicial decision-making is not only consequentialist in the sense of an outcome, it's not only outcome-driven, but it is also process-driven. So we are not only interested in the outcome, i.e. the outcome being that X won or Y lost, but we're interested in the principles. And those principles are what develops the law for future purposes, and particularly for legal scholarship.
All right. So
speaking
now,
as someone from the academic, that's a bit of a worry.
Right. So now, and I'm going to require all of you, my guests, to help me so we can use the 30 minutes to be able to exhaust the discussion on the Supreme Court judgment. Right. Now, number one, the issue one that was set down was whether or not the petition disclosed a reasonable course of action. The respondents actually wanted the case to be thrown out, to be prematurely terminated, so that we would not have gone through all of this. They said it was frivolous, it was unmeritorious, it doesn't disclose any reasonable course of action. The court held that it raises a reasonable course of action, yet it dismissed it as lacking merit. I have heard within lawyers within the NDC say that is unheard of. How can you say it raises a reasonable course of action and at the same time say you dismiss it for having no merit? Can you speak to that?
Something.
I wanted Abochi to address that very quickly. Yeah.
Absolutely. And I let me just say that I disagree with the lawyers who say the court is wrong here. The court, I think, is absolutely right on this point. A matter discloses a cause of action if it contains a complaint that is cognizable at law. The complaint must be cognizable at law in the sense that it is a complaint which is recognized in law. So if you're asking, for example, the very elementary one, trespass to land, if someone complains of trespass to land, the judges will ask themselves the question, whether trespass to land is a breach of a legal right that is recognized in law and which contains an appropriate remedy, the basis of which the court's jurisdiction can be invoked. So a matter discloses a cause of action if it contains a complaint which is cognizable in law. Now, therefore, you have the cause of action. However, having had the cause of action, that cause of action must be established on the balance of probabilities, being the evidentiary balance in civil cases. And if you are not able to adduce sufficient evidence, when the evidence burden of proof falls on you, if you're not able to adduce sufficient evidence, you may have failed to establish that right, which is cognizable. So the court has accepted that the right is cognizable, but they have rejected the fact that you have established you've established your case on the basis of the balance of probabilities, which has to do with the evidentiary basis for you making out the case. So you can have a matter which discloses a cause of action known to law, but you're unable to vindicate yourself in terms of establishing the complaint for which you brought the action.
Okay. Now, Professor Sari, what would you also say? There are some who say those who are blaming the judges for this unanimous at each point. When they were granting the application for amendments, they granted it unanimously. Since then, everything they have done unanimously. Some say that is a clear sign that this petition was dead at birth, because it clearly has issues that it's not difficult for all the judges to agree. For example, they found, as a matter of fact, and held that the petition did not challenge the validity of the election. The validity of the election was not challenged. What do you say about that?
Well, you know, I have no problem with courts giving a unanimous decision per se. There's nothing wrong with that. If the panel believe that the issues are clear, then there shouldn't be dissent for the sake of dissent. And for the same reason, I don't believe that every judge on all cases should write an opinion. Sometimes the by court opinion itself suffices. People have to understand that once judges hear the case, they don't go their separate ways and go and write separate opinions. No, they actually sit in conference and discuss issue one. What do you think? From the most senior to the most junior judge, they debate, and then they come to some conclusion, and they go through that way. And if you don't have anything to add, then really it is annoying to write just for the sake of writing. So really, we need to get away from this notion that the court should always write multiple opinions. You should, by all means, write a multiple opinion if there is a dissent, or if you are in the majority, but you want to make a point that the main or the lead opinion does not make. But if you don't have anything to say, then you should stop. I also agree with my good friend Kofi that you can have a case that basically the court allows as raising issues and yet basically dismiss it at the end as lacking merit. And he explains that very well. The short answer is that the burden of proof at each stage of the trial is slightly different. So on the dismissal, motion for dismissal, the petitioner doesn't have to do much. All the petitioner has to do is to show that there's prima facie case. And once it's that, the court will listen to what he has to say. Okay. But at the end, there's a different burden of proof.
Yeah.
I also, again, don't have problems with unanimous decisions. Now, we have to go into the details to see whether some of the unanimous decisions are justified. I will start by saying on that, the petitioner brings a novel theory. The theory that they bring is actually very novel. It's very different from the 2013 petition. In that, in this petition, they are basically challenging the denominator. You know, we have the numerator, the votes that people got, and the denominator. When you add up all the votes, what is the total valid votes cast? And they are basically challenging the denominator and the multiple declarations made with respect to the denominator. And it's a fascinating theory. The court heard them out, and the court basically says, well, look, let's use some common sense. We can infer the denominator by aggregating the numerator. You are not challenging the votes gotten by any of the candidates. You agree with what the president got, you agree with what you got, you agree with what all the other candidates got. So common sense allows us to aggregate the items in the numerator, and then we have arrived at a denominator. So if we do that, then really your case is weak. The theory you brought is interesting, and we've heard you out, but again, it's very weak because there are different ways of getting to the denominator.
Right.
So I thought on that. Where I disagree with the court is the process by which it got to the final outcome. So, for instance, I would have allowed, and I believe it should even be mandated, that once you pass the first stage, that is, if the court believes that you have a reasonable course of action, then immediately the court should order the election manager to submit all pink sheets and declaration forms and every item that they use in declaring the results to the court registry, so that all the parties would have access to that. That will limit the discovery argument because all the documents will already be at the court registry and you can easily fetch what you want. Now,
all right,
one additional discovery, I also believe the discovery should be allowed as a matter of right. Finally, I also think in an election petition, the person that has the most knowledge about what has happened is the election manager, and that election manager should be declared as a witness for the court, and he should be available for examination by all the parties.
Thank you very much. Now, yeah, the point is that, like Professor Sari is raising, the processes are circumscribed by law. So when he says you should be allowed as a matter of right for discoveries and all of these things, the suggestion then would be that you want us to put, say, the Evidence Act and the things he says in Section 166 and all of that aside, or what? But the question to you is, those who say this was so predictable, and they say it is predictable because of what had gone on in the process. Do you share the view that it was predictable because from start, it was not a case that was properly put, rather than judges that may have, conspired to want to throw something away? That's why it was predictable.
So that's an interesting question. You see, so from the beginning, we, after reading and analyzing the petition, even before it was amended, we formed the opinion based on law and good reasoning that this is not a petition, presidential election petition dispute, properly so called. And we came to the case of Rojo Metonunu and others with the Attorney General, which was filed sometime after the second election of President Kufuor, in which the main issue that the Attorney General raised was that, one, the case was filed in the wrong forum, that is the High Court. And then also it was filed long after the stipulated period of 21 days after the date of publication, or if you like, declaration of the presidential election results. But Mr. Metununu, I think their lawyer was our good friend Tony Lita, made a very strong point that this is not a petition challenging the validity of the election results. It is only concerned with a violation of Article 96, Article 63.9, 63 clause 9.
63.3.
No, rather their own was about 63 clause 9,
okay,
which is about the issuance of the declaration of president-elect instrument. In this case, it is CI 135. So their concern was about that instrument that was issued, saying that by the power in me vested, I declare President Kufuor as president-elect in the 2004 also election. That they are concerned because they raised the view that the actual votes that all the parties got should have been indicated in that instrument. And the court agreed with them that in that case, it was not a presidential election petition case under Article 63.3 and also 64.1. And so to that extent, the court dismissed the preliminary legal point. But the court held the view that the EC did nothing wrong. So we're of the view that this is another quote-unquote Rojo Metonunu case that has been clothed in the apparel of a petition challenging the validity of the election. And that is why we exercise, the second respondent exercises his right under CI 99, that is CI 99A. Respondents answer in preliminary objection. A respondent who wants to oppose a petition shall A, within 10 days after the petition is served, file an answer to the petition and may in the answer raise a preliminary objection. And in the answer, we also indicated that the preliminary answer objection should be set down for determination by legal arguments and so on. The Supreme Court, in its wisdom, and we are very pleased with it, said that they would rather defer such an exercise and incorporate their own judgment or decision in the final decision. So in the final decision, if they had agreed with us that this petition should not have been commenced in the first place, or because it lacked it raised no reasonable cause of action, it shouldn't have even gone to trial. Then there wouldn't have been any need for the other elaborate. But I think that, for me, this is a better approach, where the court, because something I can tell you that personally I have learned a lot, and I thought I had had enough until the judgment also came. And it is good for all of us. And let me also, for this, also commend President Mahama for commencing the action in the first place. As much as we know that it can raise tempers or emotions and the cost involved, it also helps to develop our legal system. And it's one of the main cases that has, in my view, since 2013, enhanced the belief and the trust of the generality of the people in the court, that where there is a dispute resolvable by law, an important dispute about presidential election in particular, go to the court. Now, I think the last count, parliamentary elections alone, the dispute are about 18. People have now resolved not to take up arms and throw out insults and injury. This shows that we have now come to the stage where we'll go to the court, and after the pronouncement, there's calm, then there's peace. Now, so when you look at it that way, but we thought that our position was not firm enough on the preliminary point. But when you then went on to listen to Mr. Siedu Nketia in particular, and he was given the calculator, and he was asked questions. For example, so you admit that it is completely wrong for anybody to use the total votes cast as a basis for determining the percentage of votes obtained by different candidates. This is a question from Akutampa. Siedu Nketia, yes. Question, anybody who does that cannot be accepted anywhere in Ghana. Yes, my lord. By this, he is saying that, yes, the EC on the 9th of December, in announcing the elections, used a denominator which was consistent with the total votes cast, which would include or included even ballots, that failed ballots or rejected ballots. But it is rather the votes that have been accepted, which is the valid vote. Though the Constitution puts it, the number of valid votes cast. That is what should be used as the denominator. So the other question from Akutampa is, you cannot use that wrong figure as a basis for your claim that there should be a rerun between the second respondent and the petitioner. Mr. Siedu Nketia answered, yes, my lord. And these questions, in actual fact, embolden us to then conclude that the petition shouldn't have even gone beyond the initial stage.
Okay, thank you. I'm going to take a break here. When we return, Reina will help us to understand whether they made what the Supreme Court finds to have been most important, whether they were able to do the most important thing. In their conclusion, they said, "We conclude this judgment by emphasizing that the petitioner did not demonstrate in any way how the alleged errors and unilateral corrections," they had issues with that, errors and unilateral corrections made by the Electoral Commission chairperson affected the validity of the declaration made by her. So, did you show that the errors and unilateral corrections affected the validity of the declaration? We'll be right back. You're welcome back. This is NewsFile, it's your most authoritative news analysis platform. It is brought to you by the candidate sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN. Everywhere you go, Ashasi University, educating ethical and entrepreneurial leaders for Africa. Europlus, where Europlus goes, water flows. Having mosquito spray and coil, pleasant on humans, tough nightmare on insects. And upper foods, it's tasty. DBS Industries, Robert & Sons Limited, Optical Services, your comprehensive eye care services provider. Now, Reina, I had posed the question to you already because that is what the whole thing came to, bottom line. You didn't show how the alleged errors and the unilateral corrections affected the validity of the declaration.
I hardly have time to deal with the issues, but I've noted a lot of issues of the judgment. The first comment I'll make is that the nature of the burden that you inundate the petitioner with would depend on your conceptual understanding of the case that we presented. The court itself has taken note of the difference of the 2013 and then the 2020 case. Here, we were looking at arithmetic issues and the figures that were presented. So burden of proof, you will notice that burden of proof, which includes the burden to persuade the believability of your case in the court, includes the burden to create a doubt in the existence or non-existence of a certain fact. Our duty did not necessarily have to do with production of, if you like, mountains of evidence, but if we could create a doubt whether or not there was existence of those base figures that culminated in the declaration, then we would have discharged that burden. And I want to use the case of Mutharika versus the Chilima case, that's the Malawi case, where the burden of proof in presidential petitions was modified to the extent that once the petitioner meets basic burden of proof, then it shifts automatically to the electoral body, that's the Electoral Commission. And there's basis for that. This is the constitutional body that has been charged with the responsibility and given public funds to be able to discharge its responsibility. In fact, it is a requirement of law that this body should have the original copies. So the best material and evidence necessary for the case was with the petitioner. You saw how all the interlocutors and admission of facts and cross-examinations were not given. I want to take this, and I'm inviting the court that if we have a future opportunity, we should look at the case of Mutharika versus Chilima in terms of the burden of proof.
You urge this on the court?
In future.
In future, yeah, because you see, the tenure of Article 64 suggests to me that any other individual could have gone to court. Okay, you don't have, I don't think there is...
If the CR99...
The jurisprudence...
Something else.
Exactly, so let me finish. So I think that this burden would have discharged. How did we create this doubt in the believability of existence or non-existence of a winner? We created this doubt because the EC itself had admitted that it committed errors. How did the court come to the conclusion that those materials did not materially affect the outcome of the declaration? There was no cross-examination. It did not produce its defense. How did the court come to the conclusion?
Let's say Dunketia admitted.
No, not admitted. No, I will refer to something. You are reading Asio Dunketia Manos, where he says that provided the figures are correct. Have you seen that or not? Yes. Well, no, listen to this. In cross-examination, page 37 of the judgment, that's the questioner. I am saying that this is the question. I'm saying that from the calculation of the figures of the practitioner and the second respondent clearly crossed more than 50% threshold. Answer, well, if the figures are correct. So it was preconditioned on the correctness of the figures.
That is
so no. I've seen comments and other lawyers.
Who is answering?
This is
if the figures are correct?
This is a PW1.
Should he be answering if the figures are correct?
No, the figures are not. No, you see, the EC
your insistence is that nobody crossed. Nobody crossed.
No, let me make. Look, I'm on a part. Let me make my point. The EC provided how many base figures? Not less than 5. Which of them were you supposed to believe in? Which of the base figures? Which is why it was important.
On which of them did you say that Nanado got about
it creates doubt. It creates.
Mahama got former President.
It creates doubt. It creates doubt.
Which of them?
Let me finish. You're interrupting now. Let me go to other. No, I don't need any assistance. Let me go to other parts of the judgment. There's a point where the Supreme Court says that agents should pull their weight, and they refer to the Nigerian and the Kenyan cases. This is a recipe for disaster. Agents should pull their weight. Let me finish. No, don't disrupt me. Agents should pull your weight. The 2024 election, the Supreme Court is asking... 2020, yeah, the next election. We're looking forward. The Supreme Court is asking agents or political parties to pull their weight. How do they pull their weight? By use of what? And you know that there's always...
By use of what? What do you mean by that?
No, but you understand when
in 2013, they said almost the same thing.
No. You see...
In particular.
That your agents are very important.
I think this judgment has taken the proposition by the 20 judgment to absurd levels. That whatever it is, okay, once you don't have... And you know what you're talking about? You're talking about Techiman South, where the place was militarized, gunshots, people are dead. And you are asking the agents that...
The only way to pull your weight is to carry guns.
To do what? How do you counter that weight?
Is that what you're saying?
No, I'm not saying that. You listen to me. This is in context.
Pull your weight. Be vigilant.
No.
Be knowledgeable on what you do.
What if you are vigilant?
If you are refusing,
Samson,
if you are refusing to sign...
No, let me land.
If you are refusing to sign,
yes,
indicate the reason for which you are not signing. If
there's a military officer on top of you, like the Chimasad, this is not even... These are things that happen. The Chimasad, you know that. It happened. That was military. People are dead. We don't even know why, how. So I am saying that it is, I am totally against that. Let me say something else. There's the issue of the courts, I have so little time, but the court raised the point of the independence of the Electoral Commission.
I'm sorry, but we have run out of time.
No, just one point. No, let me finish.
We have run out of time. I'm sorry about that.
The independence of the Electoral Commission. The independence of the Electoral Commission.
Okay, I'm sorry. Your mic is off because we have just run out of time. My guests have been Professor Kwekwa Sare, Fellow, CDD Ghana, and D&D Fellow for Public Law and Justice. Yao Diopong is lawyer, senior lecturer, Ghana School of Law, and member, Akufo-Addo's legal team. Dr. Reina Akumperia is lawyer and member, John Mahama and NDC's legal team. Dr. E. Kofi Abochi is dean, UPSA Law School. Please don't switch your dial because Joy Sports Link comes your way right away. Ghana's under-20 exploits, a new generation of possible world beaters. That's the question Nathaniel Atto will be putting to Samuel Inkum, Redwan Ibrahim Asante, and Lai Kingston. I'm Samson Ladi Anyanini. Have a good afternoon. Go and get wache. That is traditional. Have a good afternoon.